Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I now call to order this meeting of the Board of Zoning Adjustments for Brevard County, dated, December 18th, and it is now 1:30. We have a few staff announcements. Number one, we have a new member, Ms. Jennifer Clemens. She is representing District 2. Today we have an excused absence with Mr. Stephen Holmberg within District 3, but with 4 members here, we do have a quorum. So with that announced, I will ask for our Mr. Bodie, could you please read the function of the Board of Zoning Adjustments?
Yes, Mr. Chairman. The Board of Adjustment is a quasi-judicial body established by the Board of County Commissioners under Chapter 62, Article 2, Division 4 of Brevard County Code. The Board of Adjustment is empowered to hear a request for variances to the zoning regulation and sign regulation in Chapter 62, Article 6, and Article 9. Pursuant to Florida Rules of Appellate Procedure, any person or persons jointly or severally aggrieved by any decision of the Board of Adjustment may, within 30 days after the date the order is signed, apply to a court of competent jurisdiction for appropriate relief. Mr. Chairman, you have 4 items on your agenda today.
Thank you, Mr. Bodie. Could our Vice Chair and representative from District 1, Ms. Millard, please read the second reading?
Okay. Undue hardship. A variance may be granted when it will not be contrary to the public interest and where, owing to special conditions, a literal enforcement of the provisions of this chapter will result in unnecessary and undue hardship. The term undue hardship has a specific legal definition in this context, and essentially means that without the requested variance, the applicant will have no reasonable use of the subject property under an existing development regulations. Personal medical reasons shall not be considered as grounds for establishing undue hardship sufficient to qualify an applicant for a variance. Economic reasons may be considered only in instances where the landowner cannot yield a reasonable use and/or a reasonable return under the existing land development regulations. The applicant must answer a variance hardship worksheet with 6 questions. The Board of Adjustments will discuss these questions today with each applicant who has requested a variance.
Thank you, Ms. Millard. I will now address the board members, the applicants, and our audience regarding the board procedures for today's proceedings. The Board of Zoning Adjustment, as a quasi-judicial board with members appointed by the Brevard County Board of Commissioners, will utilize Robert's Rules of Orders to conduct its proceedings. The chair is asking all board members not to ask questions while the applicants are making their initial presentations. Once the applicants have completed their presentation, we will begin board questioning with the board member who represents the applicant's district. When concluded, questioning is open to the full board. The chair will recognize each board member in turn. Once all board members have completed their questioning, we will then open the floor to the audience who may be here to speak concerning the applicant's application. Anyone from the audience wishing to speak will be given the opportunity to address the board once and only once. So be complete and concise if you're coming forward to speak. At the conclusion of public comment, the applicant will be given additional time for rebuttal, as well as to present their final comments. Once completed, no further comment will be heard from the applicant or the public. The action will move to this side of the bar, and the board will make its considerations and votes. We will not use a timer for the meeting. Instead, we are asking each speaker to be concise in what they have to say. It is important that you stay on subject and avoid information that is not relevant. I don't want to hear about who said who to what. Just stick with the facts. All persons speaking must provide their name and address for the public record. Those wishing not to verbally state their address may ask the clerk at the podium for an address card. Please fill it out and return it to the clerk. Are there any questions regarding these procedures from the board? Are there any questions related to these procedures from the applicants? Are there any questions from any other persons in the audience? Seeing none, we will proceed to the next item, which is the approval of last month's meeting minutes. Board members, do you have any edits to the meeting minutes which were distributed?
None.
None.
Seeing none, I'll ask for a motion to approve the meeting minutes.
I'll make a motion to approve the meeting minutes.
Okay.
Second.
All right, we have a motion by Dr. Bass and a second by Ms. Millard to accept the meeting minutes as written. All in favor, say aye.
Aye.
Any opposed? Okay, meeting minutes are approved. Mr. Bodie, can we have our first applicant, please?
Yes, item H1, Timothy Scott Gannon and Denise Irene Gannon request variance of Chapter 62, Article 6, Brevard County Code as follows. Section 62-1340, 5B, to permit a variance of 6.3 feet from the required 7.5 feet southwest side setback for an accessory structure in an RU-1-11 single-family residential zoning classification. And this is variance application 24V00045 and located at tax account number 2417445.
Okay. Name and address for the record?
Denise Gannon, 285 Diana Boulevard, Merritt Island, Florida.
Timothy Gannon, 285 Boulevard, Merritt Island, Florida.
And let's do this together. Do you swear that the testimony you're giving today is the truth?
Yes.
Yes.
Okay. Floor is yours.
So we're here to legitimize a shed on the side of our house. We purchased a shed that's under 100 square feet, which means there's no permit required. Correct me if I'm wrong, Paul. But there's no permit required, so we didn't know that it had to be within the setbacks because we didn't have to go for a permit. After sitting through many of these hearings, we learned that it needs to follow the same setbacks. So we're here to legitimize a code enforcement violation. The Brevard County has approved our shed to where it is right now. We've had the vacated easement. All the utilities have approved that. There's really no other place to put it on our property. It's on the side, as you can see on the on the survey. It's 72 square feet. It is, it doesn't block anyone's views. It's on the side of our house, and there's really no storage in the older homes in Diana Shores, and this is really the only place that we have to store our items. So we're requesting to legitimize this.
I'd like the board to know that this item was heard on October 16th, 2024, and it was denied. They have moved the shed to be a tenth further into from the setback. So this was heard, and it's being brought up with a different setback.
Thank you. Ms. Clemens, it arises in District 2. Would you like me to begin the questioning in your stead? Yes. So we heard this before. You have moved it 10 feet in. In that move.
No, they moved
8/10.
it 1/10.
Oh, 1/10.
Yep.
0.10.
Okay. And now it meets does it now meet the setback?
Yes. Well,
No, you're
we're still
asking
asking
for-
for the variance.
For the variance,
But we
okay.
couldn't ask for the same exact variance, so we had to move it slightly.
Okay. Now, my question from before was access for emergency people to get into the back area if something goes wrong. And
You're required to be 5 feet off the house for
so
the
you have
emergency.
a
Yes.
5-foot corridor minimum.
Yes.
All right, that meets handicap
Mhm.
standards, so I guess that's okay. I'll suspend any more questioning. Ms. Clements, do you have anything to ask?
Blockage for neighbors or?
No, it's on the side of our house. You can see it on the survey. If we were to move it anywhere else, we would block their view. So that's why it's up. It's behind our fence, right on the side of the house. It's on the side of their house too, so that it doesn't block any waterfront view or anything.
And there's a fence fully around the property, correct?
Yes, ma'am.
I don't have any other questions.
Okay. Any other board member?
No.
Okay. So if you could step aside, please.
Actually, I do have one other question.
Oh,
What
wait.
what was the reason it was denied last time, just out of curiosity? Because I wasn't privy to
We
that.
had brought 3 things. We didn't get the reason why. It was a 2-2 vote, but we had multiple variances in one package. And I think it
And then
kind of
this
all
one was
got
pulled
lost.
out?
And it was a 2-2 vote that day, so there wasn't a majority. So we had a
We
couple.
other
never got the
variances?
reason why it was
Don't-
denied.
Yeah, I don't know why.
But the other 2 variance requests were granted?
Everything was
Everything
denied
other
that day, so we've
This is
been,
the only thing you're bringing back?
Mhm,
Okay.
For now.
for now.
If I may, Mr. Chair, I think that during this discussion, that you as a board had some concerns about the access for emergencies on that side of the house.
Mhm. Which now you're telling me you have a 5-foot
Oh, yes.
Yeah.
and no gates or anything that block access to the front street where the ambulances or
No,
whatever would come up, gurney going through?
no.
Okay. That was a concern about adequate access. I think, just as a point, the other side is also somewhat blocked with some.
Actually, it's
We-
wide open as
It's-
well.
It has a breezeway.
We had the pictures and everything,
Right.
but
Yeah.
there was a concern that there wouldn't be adequate access to the back. So, but this, okay, well,
That answers my question.
okay. All right, no other questions? Now you may step aside. Is there anyone in the audience who wishes to speak for or against this application? Seeing none?
The only thing I had to follow up with is, again, we went for the vacated easement. Brevard County approved that, so they had no problems with any of that, so that's all been passed already.
Okay, thank you. Oh, okay. All right. This application arises in District 2, so Ms. Clemens, you have the option of offering a motion to approve or disapprove?
I have no reason to not approve the variance.
Well, no, we're offering a,
I make a motion to approve the variance.
as depicted
As
on the.
depicted on the survey
survey.
provided by the applicant with the revision date of 4/19/2024.
Thanks for the help. All right, do we have a second?
A second.
Okay, so we have a motion.
Can you make sure you turn on your microphone and speak into it whenever you're
Can you, for the record, can you state that motion again? We were trying to
With the microphone
listen.
on.
Give me that. I make a motion to approve as depicted on the survey. I make a motion to approve the variance as depicted on the survey provided by the applicant with the revision date of 4/19/2024.
A second.
Okay, so we have a motion by Ms. Clemens. We have a second by Ms. Millard. Ms. Millard. Do we have any board discussion?
No.
Well, in that case, you've forced me to read the 6 questions. As part of our procedure, we need to read into the record the 6 questions that you, as the applicants, have responded to. I'm not going to read the responses, but I will read the questions, and these are the things that our board members consider as part of their vote. So, that special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. That the special conditions and circumstances do not result from the actions of the applicant. That granting the variance requested will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. With those 6 considerations in mind, I will call the vote. The motion is to approve the application. All those in favor say aye.
Aye.
Any opposed? It passes 4-0. Your application is approved.
Thank you for your time.
Okay. Mr. Bodie, could we have the next applicant, please?
Yes, item H2, the Vieira Company, request variance of Chapter 62, Article 6, Brevard County Code, Section 62-1511-7, to permit a variance of 400% from the allowed 25%, 100% of the units of the total number of units in a motel or hotel to contain kitchen facilities in a PUD, planned unit development zoning classification. This is application number 24V00046, located at tax account number 3019268 in District 4.
Thank you. Name and address for the record, please.
My name is Hassan Kamal with BSE Consultants, we're acting as the applicant for the project.
Okay.
Address is 312 South Harbor City Boulevard, Melbourne, Florida, 32901.
Okay, you can adjust that microphone to whatever height makes it more convenient for you.
Thank you.
Do you swear that the testimony you're giving today is the truth?
I do.
Okay. Please.
Thank you. Our application here today is for a variance request for a proposed hotel use located on Town Center Drive, just west of Lake Andrew, just immediately south of here, across from the Avenue Shopping Center. I do have some exhibits I'd like to pass out. They're similar to what was in your package, but there's a couple of additional bits of information that I want to share with you.
Okay, how many copies do you have with you?
I think I have 8.
Okay, one needs to go to staff.
Thank you.
So the first page of the application was in your staff report. It's just a site plan showing where the proposed hotel would reside. Again, it's adjacent to 2 existing facilities just located west of Lake Andrew Drive. The second page is a floor plan showing the units and showing the efficiency or kitchenette uses proposed. And that the usage that's shown there is duplicated throughout, because what we're requesting is that, and this is the brand, this is a Residence Inn, so all the units contain small kitchenette areas, and they're intended for extended stay. And the reason why this hotel is coming here is because the way Vieira is developed, where we have the USSSA facility, we have the regional park, we have the government center, and Residence Inn is a Hilton brand, so that's their brand. They do 100% efficiency units. And they've looked at this market and said this is a great place for them because of the uses that exist within proximity to the site. And then the third page is just an overall floor plan that shows how those units sit. And the last page I have is just kind of a location map. And the location map and an aerial photograph basically document the site location, the proximity to all those features and attractions that I mentioned earlier, such as the USSSA facility, the regional park, all the offices and government centers here. What's interesting about the map, too, it also points out 2 adjacent or nearby hotels that are extended stay hotels. The home with 2 suites, which is actually another Hilton brand, which was developed several years ago by the same applicant that's doing this, is 100% extended stay hotel. And then the Homewood Suites, further up on the corner of Lake Andrew Drive and Parada, is an extended stay hotel. Both of those projects are in the exact same zoning classification. They're within the Central Vieira PUD and are subject to the same regulations. I don't know why, but they were not required to obtain a variance. We have had conversations with staff about the applicability of this code and whether it's being interpreted or applied correctly to this site. And that's maybe a discussion for later on. But the point that we want to make today is that this application is suitable for the site. It's driven by market uses. There's no adverse effects to adjacent properties. There's nobody harmed by it. And we would request the board's consideration and approval of the application as submitted.
Okay. Your application arises in District 4, which is, our representative is Dr. Bass, and you have the floor for questions.
Yes, I just wanted to make sure I'm looking at this correctly, but when I'm looking at this, this is the Fairfield Hotel, right, or the Fairfield? I'm sorry.
I'm sorry.
The-
The parcel in yellow is the proposed parcel.
Right, and then this is the Fairfield Hotel?
That's the Fairfield.
Yeah, that's what I thought. Oh, yes, okay. This area is hotels, as you said. It's on Lake Andrew, it's across from the mall. You're not going to be interfering with any homes or any living residences. And the Residence Inn, as you said, does have a kitchenette available to the people. That's one of the purposes people stay there. So I don't have any questions. I'm familiar with this area, and I'm familiar with the Residence Inn. So it's quite clear to me. I have no questions. Anybody else have any questions?
I do have a question. It's probably going to be a combination of you and staff. What is the basis of the 25% of the unit? Is it a fire code? Is it,
It was a section of code that was added to limit the full-time residents in the tourist-related zoning district. That's really the why.
so the idea was that you had to have a larger unit in
Correct.
order
It
to
was,
accommodate?
TU2 is a traditional tourist-related zoning district, and where it wasn't appropriate to have long-term residents in a tourist area because of the light, the noise, and the impacts that are created from that use.
So the idea that the kitchen could only occupy a certain amount was to,
Correct, that it remained, the primary use was a motel, not in
Not a
this
re-
case, is a full-time residence.
okay.
And that's,
Okay, yeah, that's, what's the basis of 25%? And Ms. Clemens has a question also.
Was that changed prior to the?
Microphone.
no, so as Mr. Kamal had mentioned, there are 2 other residents in that have kitchens. Unfortunately, staff made mistakes in prior review of those, and Mr. Hassan has been notified of that. So we made a mistake in that. Unfortunately, we caught it this time, and this is the remedy to do that. And the variance, staff doesn't see any issue with it. It's just one of the code requirements that when you, in this zoning classification where you have B1, we use the TU2 zoning standards, and that's where that is coming into the 25%.
Okay, just a little background. Okay, well, that's all the questions I have. Does anyone else have a question? Another question? No? Could you just step aside, let me ask the audience? Is there anyone in the audience who wishes to speak in favor or against this application? Seeing none. Any final, before we deliberate?
I'm sorry?
Any final, anything before we deliberate?
No, I think we've outlined and met all the criteria in the variance worksheet, and we request the board's consideration and favorable action on our request.
Thank you. All right, well, this arises in your district,
Yes.
Dr. Bass, so what?
I just have one question for Mr. Bodie. I can't read it on the drawings. What's the revision and the date on this?
for her
The drawing.
motion?
Mhm.
No, you're good.
I can't.
Yeah, I can't read that either.
There-
If I'm reading this correctly, and Hassan, let me know if you agree. I'm reading this as 9/16/24.
Sounds good.
That's the date, the revision of the survey?
That's
The
yes,
drawings.
that's the date on the survey.
Oh, okay.
Well, go ahead.
I have nothing else to ask. We're okay? All right, great. I make a motion to approve the variance as depicted in the survey, dated 9/16/24.
Mr. Chair, that date is from the site plan. This is a little bit different, so I would reference the site plan that's in this.
As opposed to the
So,
survey.
yeah, so
Please
Just-
restate.
Okay. I make a motion to approve the variance as depicted in the site plan dated 9/16/24.
Thank you. Do we have a second?
A second.
Okay, so we have a motion to approve by Dr. Bass, and we have a second by Ms. Millard. Any discussion? Okay. All right, having no discussion, then I will read the 6 criteria. All right. That special conditions and circumstances exist which are not applicable to this chapter and will constitute unnecessary and undue hardship on the applicant. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. That granting the variance will be in harmony with the general intent and purpose of this chapter, and that such use variance will not be injurious to the area involved or otherwise detrimental to the public welfare. With those 6 criteria in mind, I will call the vote. All in favor say aye.
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 Any opposed? Then the motion passes unanimously 4-0, and the application is approved.
Thank you.
Okay. Mr. Bodie, may we have the next applicant, please?
Yes, item H3, William Simon requests variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1341-5A to permit a variance of 1.9 feet from the required 20 feet front setback for the principal structure. Variance number 2, Section 62-1341-5B to permit a variance of 4.1 feet from the required 7.5 foot side west setback for an accessory structure in an RU-1-9 single-family residential zoning classification. And this is located, variance application is 24V00047. Location is tax count number 24-08868 in District 1.
Okay, I see our applicant has come forward already. Could I have your name and address for the record, sir?
William Simmons. Wait.
Could you speak clearly in the
Sorry,
microphone?
William Simmons, 6505 June Drive.
Okay. Do you swear the testimony you're giving us today is the truth?
Yes, sir.
Okay, you can adjust the microphone a little closer if
Okay.
it makes you more comfortable.
So, I bought this home 3 years ago with a VA loan. I recently applied for permit to have a dock built. The dock builder required me to have a newer survey done. The one that was provided at the time that I bought the home was too old. They wanted one 90 days or newer. Ended up paying for 2 different surveys to get done, and it was brought to my attention that I have 2 existing issues, the ones you just described. I bought the house this way, the structures were already there. The VA inspector never flagged anything as having an issue, so I'm asking for a variance for those 2 items. And the shed is really the big issue with me because I'm a mechanic by trade. I have tons of equipment and tools. This house doesn't have a garage. I left a home that did. This shed provided the protection that I need for that equipment. So I guess I'm at your mercy to approve or deny.
Okay. Your application arises in District 1, which is represented by Ms. Millard, and you have the floor for questions.
Good afternoon.
How you doing?
So we're here today because you purchased a home 3 years ago.
Yes, ma'am.
Doc built, two surveys were done, correct?
Yeah, I had to pay for 2 because the first one had some issues.
Okay, and because you don't have a garage, that's why you're standing before us today as well, correct?
Yes, ma'am.
To protect your shed
Yes,
and
ma'am.
your tools. Okay, so looking at I drove past your home. One question is that I see you have a neighbor to the right side of you, correct? Or is that the
Facing-
left?
Yes.
Oh, that's the,
Yes,
okay,
almost, yeah, the one that's really next door to
Right.
me, yes.
okay. And that won't be objected in a view or anything like that?
No, me and him get along really, really well. As a matter of fact, the space between the shed and the fence, I let him plant his garden,
Okay.
so, yeah.
Perfect. Okay. And the second one was for,
I believe it's the front porch.
correct.
And I don't know when any of these structures were built. My neighbor's been there 20 years, and he told me that they've both been there a long time, so.
Right,
he
so tell me
couldn't
about your
remember.
front porch.
I guess when the first survey was done, they measured from the house. The porch was there, but they measured from the house to the easement. And I think that's where they made the mistake, because the second guy that did the survey, his measurement showed from the post, which is a few feet out from the house. He measured from the post to the easement, and that's when it got flagged.
Okay. Okay, I have no other questions. Thank you.
Yes, ma'am.
Any other, Dr.
No,
Bass?
I have none.
Oh, Ms. Klein? All right. No, I don't have any questions. I need to just do a procedure if you just step aside. Is there anyone in the audience who wishes to speak in favor or against this application? Seeing none, please return. Final comments?
Yeah, the other thing's going on, the initial thing that happened, I bought the house because the wife wanted the house. I didn't really want the house, it didn't have a boat dock. She said, buy me the house, I'll get you the boat dock. So this is where we're at. This all came about from a permit for a boat dock when all this got discovered. She's got $30,000 in a loan she's been paying 5 months now to pay for this dock. She's making payments on this, and I can't have a dock until this is resolved. So,
All of us married people understand your pain.
she's not real happy with me right now, but
Let's see what we
again,
can do.
right.
Thank you.
Mhm.
Okay, Ms. Millard, you have the floor for making a motion.
Well, I'd like to make a motion to approve this variance with the S on the end, because it's 2 with this. And I want to approve it as depicted on the survey provided by the applicant with the date of 10/2/24.
Okay, do we have a second to that
I'll
motion?
second that.
Okay, we have a motion by Ms. Millard, second by Dr. Bass, to approve this application. Do we have any discussion?
No.
The only comment I have is it's really out in the open there. If he's good with the neighbor, then I don't see any real harm to the neighborhood on this at all. So with no further discussion, I'll read the 6 considerations that you're all going to keep in mind as you make your vote. And those are, that special circumstances and conditions exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification, that the special conditions and circumstances do not result from the actions of the applicant, that granting the variance requested will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. The literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such use variance will not be injurious to the area involved or otherwise detrimental to the public welfare. With those 6 criteria in mind, I will call the vote. All in favor of approving the application, say aye.
Aye.
Any opposed? The application is approved 4-0, and your variance is also approved. No recess. No recess. Okay. Mr. Bodie, may we have the next applicant, please?
Yes. Item number H4, this item was continued from the November 20th BOA meeting, and the vote was 2-2. It was recommended that they come back till they have a majority. But the item is John Beckstrom and Lisa M. Beckstrom request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-2118, D2, to permit a variance of 7.5 feet from the required 7.5 feet from the required side south setback for a dock and a watercraft. And variance number 2, Section 62-2118, D2, to permit a variance of 7.5 feet from the required side northeast setback for a dock and a watercraft in an RU-1-11 single-family residential zoning classification. And this is application is 24V00044, located at tax account number 2418448 in District 2.
Okay, thank you. I want to do a little bit of housekeeping here. It appears that that there are audience members here to speak either in favor or against the application. Is my assumption correct? Would you raise your hand if you intend to speak for the application? Okay. Would you raise your hand? Okay. Would you raise your hand if you intend to speak against the application? Against. And for. Okay. That's not too bad. I was looking to ask you to consolidate to one speaker for, but it appears you already have just one speaker. So we'll move on. Welcome back.
Thank you, Mr. Chairman. Good afternoon.
I got to go through the same thing. You're an attorney, right?
That's correct.
Okay, so just name and address for the
Yes.
record. Then.
My name is Cliff Repperger. My business address is 2101 Waverly Place, Melbourne, Florida. I'm an attorney with the law firm of Whitebird, and we represent the applicant, John and Lisa Beckstrom.
Okay.
And
as an officer of the court, I will not swear you in.
Thank you.
You're under those bar regulations.
Thank you. And with me today, I have the applicants, John and Lisa Beckstrom. We also have the dock builder, Renell Burial, who is with us as well today. And I know that we heard this last time, and so we do have the PowerPoint, and I will go through the item again for the benefit of Ms. Clements, who was not here last time. As you may recall, when we last visited with you, we had gone through the presentation. We could not get any consensus vote on the matter, and so we requested that the matter be tabled or continued to this meeting so that we could have the D2 representative appointed. We now have that, and so with the understanding that Ms. Clements has not seen this presentation before, we will go through the presentation again just for the benefit of everyone, but I'll try to be as brief as possible for the benefit of the members that have already heard the matter. At the outset, however, there are a couple of matters that I'd just like to address right before we go into the presentation, which is we do have some letters of support. We had them at the last meeting, and I just want to make sure for the record that we have noted the letters of support that we have. At the last meeting, we had submitted 2 letters of support, one from Melissa and Richard Riccio, and they are the owners of 325 Artemis Boulevard, which is on the east side of the neighboring property to the subject property. And I can identify those properties to you on a map if you would like. But they're on the east side of the property that is immediately adjacent to the east of the subject property. We also have letters of support from Thomas Fagans and Maria Samudo, who are the neighbors directly on the southwest side of the subject property. So they were also in favor. And from the Arriccio's letter, I could just read that. It says, to whom it may concern, the Arriccio Family Trust has no issues with the variance for the property at 305 Artemis. We have no issues with the dock and watercraft on this property. Our property is located at 325 Artemis within 200 feet of this request, and we have no issues with the request. The Fagan and Samuda letter states, to whom it may concern, please accept this as our written consent and support in favor of the above stated variance. We fully support the Beckstroms and do not oppose any aspect of this proposed variance. I assume that those 2 letters are in the record. Is that correct, or would you like me to resubmit them, staff?
I believe that those letters and support are in the packet.
Okay. So those are the 2 that are in. The ones that we have additional letters of support that are not in your packet. There is a letter from the owner of 1430 Cepheus, which is located to the west of the subject property. That is J.W. and Charlene Craddock. Their letter states, and I have copies as well, we are writing this letter in support of John and Lisa Beckstrom's request for a variance to rebuild their dock. We feel it would only be fair to them as they followed all the specs set forth by the county and the building permit they were issued. When the dock was complete, the county inspected and signed off on the permit. We know that you will take all information into consideration and hope you will find in favor of the variance for the Beckstrom. So that is from 1430 Cepheus Court. Also a letter from Pat Wiley. And Pat Wiley it was within the same subdivision, 460 Diana Boulevard. They are a few streets to the north, or a few blocks to the north. It's in the Diana Shores subdivision. Pat Wiley states, to whom it may concern, I'm writing to provide my support of the variance request submitted by John and Lisa Beckstrom at 305 Artemis Boulevard, Merritt Island, Florida, 32953. As an experienced boater, after reviewing the subject property, I do not agree there is a navigational obstruction. I support the approval of this request. We also have a letter from Brian Reinert, and Brian Reinert's address is 1380 Cepheus Court. That is also on the block to the west of the subject property, on the same canal. This property is located on the same canal. It says, Dear Brevard County Board of Adjustment members, I am writing to express support for the approval of the variance requested by John and Lisa Beckstrom at 305 Artemis Boulevard, Merritt Island. As I indicated in my in-person remarks at the November 20th Board of Adjustments meeting, and reiterating now, the piling in question as exists today does not pose a navigational hazard to Mr. Guthrie in any way. The variance request before you today, if approved, will in no way impede Mr. Guthrie's ability to access his dock or inhibit his ability to enjoy the Indian River Lagoon via his boat or jet ski. I consider myself a friend to both John and Lisa Beckstrom and Tom Guthrie before attending the November BOA meeting. After witnessing Mr. Guthrie's attorney attack the integrity of both the Beckstroms and the marine contractor, it is clear to me that this opposition has nothing to do with Mr. Guthrie's claim of issues in navigating in or out of his dock and anything to do with the animosity against the Beckstroms. Oh, and everything to do with the animosity against the Beckstroms. Thank you for your time and support. Thank you for your time and support, and hope that in the end you approve this request for a variance. That is Brian Reinert. Also Tracy Reinert, same address, 1380 Cepheus Courts, writes, Dear Board of Adjustment members, thank you for your consideration for a variance approval for Lisa and John Beckstrom residing at 305 Artemis Boulevard. I am writing to express my support for approval. I will be out of town for the December meeting, so I am writing to you so that my voice will be heard. At the last meeting on November 20th, there were 11 neighbors, myself included, of John and Lisa that attended the meeting in person, as well as a couple of letters from others, all who were in favor of, all in favor for the variance. The meeting was so important that many took off of work to attend and support the Beckstroms. Since there were so many people at the meeting, we were asked to only pick a couple people who would speak for the group. I wish we all got to speak and say our names on record to support the Beckstroms variance request, and also the letters were read out loud for the recording. Mr. Guthrie has plenty of room to navigate and maneuver his boat, to back out and to pull in. It is apparent by both Mr. Guthrie and his attorney's statements that this isn't about the piling, but rather something personal. I have known Lisa and John to be honest neighbors who live their lives with integrity and kindness. Please approve this variance to allow them to enjoy their waterfront property peacefully. Thank you for your time, Tracy Reinert. And those are the letters of support that we have. I will submit those to staff.
So can I get copies of those letters?
I'm giving them to you right now.
So, Mr. Chair, we're going to make copies of those. We're going to have a copy for you. Okay, and then we will give copies to opposing counsel as well.
Let me poll the board. Do you need copies of those, or the readouts are fine? I think, yeah.
All right. With that out of the way, a couple of points that I just wanted to hit on also before I go into the main presentation. And one of those would be, I want to show you a copy of an aerial photo that was pulled from the Department of Transportation aerial site A+ website. This is the Florida Department of Transportation A+ aerial website from 1980. Do you mind if I approach? I have 8 copies. Should I give to staff? Do you want the copies distributed to you?
The staff will, yes.
I'll give
Please.
one to council.
Got enough paper on the desk? Thank you.
Thank you.
This is actually very similar to what's in the packet.
That's not in our PowerPoint presentation, but I will be referencing it as we
It's on the
go.
back of the packet.
Say that again?
It's on the back of the packet.
Interestingly enough, that's the current picture today on the back of the packet, and
This
that's
is
1980, which is what the aerial is, which demonstrates exactly my point that I'm going to get to in about 1 minute. 40
Sorry.
years, and the situation really hasn't changed. But I digress for a second.
My apologies for
Yeah.
interrupting.
Well, you helped me to make the point I was trying to make. And I wanted to talk a little bit about the lot history as well. There were certain things that were said at the last meeting, particularly by Mr. Guthrie and his attorney, who were in objection, about the fact that the lot was in some way like a substandard lot, or was not paid for by full market value, or didn't have fair market value, or didn't carry with it the right of entitlement of waterfront use. And that's just not accurate. That, as demonstrated in the aerial, the property has been used for waterfront for over 40 years, of a slip of similar size to what is being requested in the current application. At the time that our clients purchased the property, they paid fair market value for the property. In fact, the fair market value of the current property is listed on the property appraiser's website, the market value, at $554,890. This was listed currently on the Brevard County Property Appraiser's website. Mr. Guthrie's property is listed at $575,610. So really not that much different. In addition to that, the Beckstroms paid far more than market value for their property, in that they paid $635,000 for their property in 2021. So they did not pay a reduced price for this property. It was not marketed below fair market value, and there was always an expectation of waterfront use with this property. In fact, at the time that the Beckstroms purchased the property, there was the existing lift, which supported the same size boat of what the variance application that we're asking for today would support. So any claim that there was some expectation of the Beckstroms in purchasing their property that they wouldn't have waterfront use is just inaccurate and contrary to what the facts and the history show. So just to kind of go, and I promise I'll go as quickly as I can through our PowerPoint presentation, if I can get that back up on the screen. So what we're asking for today, and I just can't reiterate this enough, is to try to solve a problem that exists. The Beckstroms are trying to solve a problem that really didn't arise through their own doing. It's just a problem that they're now faced with that they have to come back and try to cure. We believe that what we're asking for today will cure that problem. The problem is that the current dock and lift serving the subject property is over the projected lot line by approximately 2.5 feet. There's a reason for that, and we'll talk about that, but what the code provides is that a dock and a lift structure in a boat can be no closer than 7.5 feet to the side property line as projected out into the waterway. So on this lot, and this is the plan of what is being proposed. This is not what's there currently, but this is what we are proposing to do. Right now, we have a post that is over, and if you see the triangular line on this diagram, is the building envelope in which the owner has to work with to be able to get to the extended lot line. So the triangular piece is the lot lines as extended, and you'll see that the plan uses every bit of available space that it can to get the boat, the existing boat, and reconfigure the lift so that it fits within the triangle. However, we can't be 7.5 feet from that, and so we need a 7.5 feet variance to get within the triangle. Right now, we're over, but we're trying to get back inside the triangle. I'll talk about it a little bit in a few minutes, but this is exactly the same type of variance that has been granted by this Board of Adjustment in this same subdivision for other lots that are similarly situated. So all the Beckstroms are asking for is the exact same variance that has been granted by this board previously, including at the last meeting, I'll add. This is a copy of the plat for the subject property. So you can see the Beckstroms own Lot 81 and part of Lot 80, a sliver of Lot 80. And so their frontage, the frontage of Lot 81 is 28.23. Mr. Guthrie, who lives to the east of the subject property, who is an objection, Lot 82 has approximately 138 feet of frontage. So the Beckstroms have a limited frontage based on the fact that there's a pie-shaped lot. I will note that at the last variance hearing, again, variance 24V00037 was a corner lot on Merritt Island, literally identically similarly situated to this lot. It looks identical to this lot, and for that property, this board granted a 7.5 foot variance from the side lot lines for that property. So I understand that the board's not bound by its prior actions and that every variance is to be looked at on its own. However, the board just did that at the last meeting on a similarly situated lot. This is what the current aerial shows. This is the current photo of what's there. What you'll note is that the lift has a cover on it, and so what you see there, it's not that the dock takes the full length of the property, it's just that that's the cover covering up the pilings, and that's just an aerial to kind of give you a kind of an orientation of how the property is situated today. In this subdivision, in the Diana Shore subdivision, this is a common problem. The subdivision was built this way. One block to the east, this is the situation. You have lots, corner lots, and docks that are protruding beyond the lot lines as extended by the code definition. That's one block to the east. This is 2 blocks to the east. Same exact problem. Same exact subdivision. This is 1 block to the west. Exactly the same problem. And if you'll note, particularly with regard to the corner lots, you'll see that this is not a substandard lift size. This is a fairly larger boat size or a normal residential boat size. There is no expectation that those boats on corner lots are going to be smaller in the Diana Shore subdivision. This is 1 block to the north. Exactly the same problem. Now, if you go back and look at the history of this site, and this is interesting because this is an aerial that was taken right from the property appraiser's website from 2007. And in 2007, you'll note that there was a lift, that this dock not only had a lift on it, or this property not only had a lift on it, but it also had a wraparound dock on it. And it was that way for quite some time, because if you look at the 1980 aerial, you'll see that it actually looks like it's more than just the lift that's on the aerial. It's not quite so easy to see, but you can see that it looks like there's more of a wraparound dock there than just the lift. But we're going to show you other pictures as well. But this is what it looked like back in 2007. It had been that way for quite some time. This is what the property looked like in 2012. This is, again, another aerial website shot taken directly from the property appraiser's website. Mr. Guthrie purchased his property January 17th of 2012. This is what the property would have looked like when Mr. Guthrie purchased his property. So Mr. Guthrie would have understood that there was not only a lift there, and you can see that you can see the lift in the aerial of the picture, but also the wraparound dock was there as well. And that's what it looked like in 2012. At some time after 2012, the wraparound dock was taken away, and we were left with just the lift. And this is what the property looked like in 2021 when the Beckstroms purchased their property. Now, again, the suggestion is that the Beckstroms knew that they wouldn't be able to put a dock, a normal residential boat on their property. However, this lift would have supported a 22-foot boat, which is a reasonable residential boat that the Beckstroms are asking to keep on their subject property. It's literally, that's how the property was when they purchased the property. So they had every expectation that they had waterfront use and that they could dock their boat on the subject property. And not only that, I might add, but Mr. Guthrie, who's now in objection to this, or to what's being requested, would have lived with either that lift or the wraparound dock for about 9 years before or at the time that this aerial was taken. So, you know, for Mr. Guthrie, and that dock would have likely been non-conforming to the setbacks as well. It probably would have been over the line and would have been deemed non-conforming by the county at that time. But that's the condition that the property was in for 9 years prior to the change that has occurred that Mr. Guthrie would have lived with. Now, just a little bit about that permit history. Again, at the time that the Beckstroms acquired the property, there was an outstanding permit for a new boat lift and dock that had been pulled by a prior owner. That permit was not finalized. As part of that permit that was approved for construction, you can see that it included the lift and the posts, the reinstallation of the pilings for the boat lift. It was approved for construction, but again, that permit was not finalized. The dock or the lift was still standing at the time that the Beckstroms purchased the property, but this permit, for whatever reason, was not finalized. However, the Beckstroms pulled their own permit in 2022 for restoration and repair of the seawall. And so that permit was pulled 2022. It was approved and marked as final November 29th of 2022. This is a copy of the engineering plan that accompanied the 2022 permit that the Beckstroms applied for. And you'll note that that was approved for construction. It also shows location for the boat lift to be located and the pilings relative to the property line end, which would be right about around here. So you can see that it's clear to everyone that the piling would have been over the line at that time. This was the plot plan that was included in that submittal package, which also shows that 4 pilings to be reinstalled for the future boat lift. Pilings would be installed, and it showed basically where they would be reinstalled on the plot plan.
Mr. Chair, can I interrupt for a second? I just want to clarify that permit that Mr. Rippinger is referencing was for a seawall. Seawall permits are not reviewed by zoning, which regulate the size and where the boat dock is. So just to clarify that zoning did not review this boat dock when it came in.
Right, and we're not pointing the finger at anybody, and we're not saying that anybody did anything wrong. I'll note that the pilings were at issue in the permit because reflective tape was mentioned in the permit as a necessity for those pilings. But nevertheless, we understand that zoning's position that they didn't review the permit, and we're not saying that zoning or staff or anybody did anything wrong. It's just a matter of fact of what it was. The plans that were submitted that were approved for construction reflect what they reflect. So it is what it is. Unfortunately, this is the as-built survey of what is currently existing. And so and that permit, again, was finalized. The 22 permit was finalized. Unfortunately, this is the as-built survey that was submitted to the county that was finalized, which shows, and you can clearly see the problem, you've got one piling that is over the lot line, and that's the offending piling right there. And that therein lies the problem, because that's what's existing, and that is what has created the problem that we need to come back and cure today. After the seawall permit was pulled, there was also an electrical and installation of boat lift permit that was pulled. And that was 22 BC 20542. That was approved as final on December 6, 2022. And you'll note that that was also approved for construction, showing that there was a lift that was going to be installed, and that the permit speaks for itself.
So, Mr. Chair, again, that was for electrical permit. Zoning does not review electrical permits, even though it was for a boat lift.
I'll clarify that
While we're making that clarification, I just want to, for the other board members, seawalls have a particular exemption within the rules where they're allowed to extend, I think it's 18 inches beyond the existing seawall without a lot of regulatory review.
Yeah, that's all reviewed by Natural Resources, but I believe it's 18 inches for a max of 4 feet.
Okay,
total.
for a maximum, but they put in seawalls frequently.
Correct, but zoning does not review that.
Just with the understanding that it is less disturbance to the water and turbidity and things if you don't remove the old seawall and just place a new one in front of it. And that's just board, so you need to understand that. Okay, sorry for the interruption.
Yeah, and again, I'm not going to argue with staff. What I am going to say is that the permit application was amended to include installation of the lift. That is in the package. And so the lift was at issue in that permit. But again, we're not pointing fault here. It is what it is. This is just a situation. The point is, the Beckstroms tried to do everything that they could do to get the current structure permitted legally. That's what they tried to do. There was also, there's a code enforcement case that's currently active on the property. It was reported by the neighbor, Thomas Guthrie. You will hear from him and his attorney in objection to this variance application momentarily. That case is pending right now. It's stayed pending the outcome of this variance and any curative action that gets taken. This is a picture of the boat lift as it currently exists today. Just to give you some orientation, so you can see the farthest to the east pilings, which would be on your left side of the picture. If you actually look at them in reality, they kind of sit mid-center of the property just based on the orientation of the way that the lot is configured. But unfortunately, the way that the lot line is extended into the water by code, it just results in that cutting off of the piling by 2.5 feet. Here's a view from the water side where you can look back at the subject property. This right here, if I can use the cursor, this would be the offending piling right here. And then you can see the gap distance between here and Mr. Guthrie's dock structure to the east. This is another shot of the distance and the gap between the properties. Our clients have measured there's 42 feet between this piling, that the farthest, I guess, west piling that Mr. Guthrie has on the canal side, and the offending piling that of our clients. This is a picture of the gap between the subject property, showing the amount of space that Mr. Guthrie has to navigate his boat into his slip. And again, I'll reiterate the fact that this is no different than the same gap that Mr. Guthrie had for 9 years preceding the seawall being restored. So it's exactly the same as it was when Mr. Guthrie purchased the property and for the next 9 years, and exactly the same as it was for 40 years back to 1980. Here's a picture of, and this is a video clip, I showed it last time, Mr. Guthrie navigating his boat into his slip. Just show it again for the benefit of Ms. Clements. There does not appear to be any difficulty in navigating into the slip. So again, what we're here to do is to try to fix this problem, the fact that the post is over the line, by going back to that plan that we showed you that has everything within the triangle, to try to fix it and make it code compliant, have the variance granted, and that way we no longer have a code enforcement issue. The applicant needs to show that they meet the various criteria of section 62.253A. I'll just go through them very briefly, that special conditions and circumstances exist that are not applicable to other land structures or buildings in the applicable zoning classification. We've asserted this in our application, but because of the orientation of the property, the way that the property is configured, obviously that's not something that is applicable to all lots in the zoning classification. It is a unique lot in that it does have limited frontage. That obviously is not something that the applicant did. This subdivision was subdivided long ago, and the applicant did not establish the property lines where they are. And that, so as to number two, that the special conditions did not result from the actions of the applicant, they did not. That the granting of the variance will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. The applicant's only requesting the ability for adequate and similar usage of the publicly dedicated platted canal that is enjoyed by other similarly situated properties within the same subdivision and the same zoning classification, R111. I've showed you all of those examples of other lots in the same subdivision that have the exact same situation. The applicant is only seeking the same use that has historically existed on this same exact subject property. The applicant notes that similar in kind variances for docks and lifts have previously been granted by the Board of Adjustment on lots in the Diana Shore subdivision, and we'll talk about that in 1 second. Number 4, that the literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter and will constitute unnecessary and undue hardship on the applicant. the literal enforcement of the code would deprive the applicant of rights commonly enjoyed by other properties in the same subdivision and zoning classification to construct docks and utilize the platted canal. The literal enforcement of the code constitutes an undue and unnecessary and undue hardship on the subject property and creates an inequitable burden on the applicant's property and the right to use the subject property and the dedicated public canal. That the variance is granted is the minimum variance that would make possible the reasonable use of the land, building, or structure. Again, we've showed you that we're literally using every available inch of space that we can within the extended triangle to try to put the lift back into a spot that we can make it code compliant. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, such that the variance will not be injurious to the area involved or otherwise detrimental to public welfare. The existing accessory boat dock and lift does not detrimentally affect the adjacent or neighboring properties. The granting the requested variance will allow for a reduction of the existing nonconformity of the existing accessory dock lift as reinstalled as part of the prior seawall restoration. The requested use is consistent and uniform with such uses on similarly situated adjacent and neighboring properties, and the applicant notes that similar in-kind variances for docks and lifts have been granted by the Board of Adjustment in the Diana Shore subdivision. We're just asking for the exact same right to be granted to this particular applicant. And again, talking about those, in January of 2024, the Board of Adjustment granted a 7.3-foot variance in Diana Shores for Goforth and Morno. It was 23V 00050. These are all of the dock variances that have been granted by the BOA this year. There was a projection variance, a total side ANS projection variance with 24V 00005. There have been a number of projection variances, and then again, as we talked about at the very last meeting, the BOA granted variance 24V00037, which was the corner lot on Merritt Island for 7.5 feet on a pie-shaped lot in an exact similar situation on Larmont Court on Merritt Island. So for those reasons, we do believe that the variance should be granted, and we're asking for the Board of Adjustment's support and approval of the requested variance. We'd be glad to make ourselves available for questions.
Board questioning proceeds with, let's see, this is District 2, which is our new member, Ms. Clemens.
I don't have any questions at this time.
Okay. Anyone? I think all of us have heard all this before, except for Ms. Clemens.
With that being said, we appreciate your time. I would request just a brief period of time for rebuttal of the opposition that you are sure to hear.
Okay.
Thank you.
All right. At this time, we ask for anyone in the audience who wishes to speak in favor or against this application, and I would ask that we allow the 4 people to come forward first, and then we will hear from the opposition. So if you are speaking in favor of this application, please come forward. I need your name and address for the record, ma'am.
Sure. Colleen Lisi, 1405 Cepheus Court, Merritt Island.
Okay. Do you swear that the testimony you're giving us today is the truth?
Yes, sir.
Okay. You gave us your physical, or you gave us your address. What is your physical location to the property in question?
Yes, so Lisa and John live on my corner. So I'm on Cepheus, they're on Artemis.
May I ask, is that across the street?
It is.
Or on, okay.
So I live.
Just so we get oriented.
Yes.
All right, thank you. Go ahead.
So I am friendly with both parties. So that has nothing to do with any of that. I do kayak on the canals. So the other day I said, let me go down and check for myself, because I was here last month and I thought, let's just see. Because I go down all the canals, and I did go down there and I said, I don't understand how there should be any issue maneuvering the boat in and out. I'm not an expert. I do have a boat. But I didn't see any issue. And John and Lisa are willing to move the pole at a cost, of course. This is costing a lot of money, as we probably all know. What else could they possibly do? Take the whole thing down? I'm starting to think there's really not much that's going to be okay. If you understand where I'm coming from. So I didn't see anything that would be obstructing.
Okay. Does any board member, I guess it starts with you as well, do you have questions for this witness?
I don't have any questions.
Okay. Thank you.
Thank you.
Mr. Attorney, are you all together, or is that a separate?
We're all together. Here, let me.
Yeah. Go ahead.
Nick Vidoni, business address 959 North Cocoa Boulevard, unit number 5, Cocoa, Florida, 32922. We're all together as a group, but I do have some people that will be speaking. I have Mr. Guthrie, Patty Hill. I have Josh Long, who's an expert in building docks and boats, or building boat docks and lifts. And I think that's who I have, those 3 people in addition to myself.
You're facilitating, shepherding?
I'm just going to let them speak, just like last
Okay.
time.
Okay.
And I do have a PowerPoint presentation and some exhibits. May I begin? Yeah. Okay.
Mr. Chair, just so you're aware, the photographs that was provided at the last Board of Adjustment meeting is in your packet.
Okay. Are these duplicates again?
Some of these are different, some of them are the same, and I do have a PowerPoint.
Okay.
Is there a mouse for this? All right.
Can I just get clarification? Where is that PowerPoint coming from?
Where's it coming from? USB?
Okay, so typically in order to show a PowerPoint presentation, it needs to be submitted for staff, and staff reviews that prior. We need to have at least 24 hours just to make sure that everything is correct and there's no offensive language in that. And Greg, you can correct me if I'm wrong. So I guess it's up to you all to determine whether you're going to hear it, but just so you're aware that staff has not reviewed this PowerPoint presentation.
Is there any objection from a board member to view the PowerPoint? No. We will trust that there is no falsities or objectionable language
Yeah,
in the PowerPoint.
even though we're dealing with boating, we're not using sailor language in this proceeding. So the first part is where things are right now, where the lot lines are if you extend them out. That's the red portion going out into the water. That gray portion is the hooded portion of the Beckstrom's current boat lift with the roof on it. Now, if you looked at the variance, what they're using is a 22-foot boat. So that hood that we're looking for, that's at least 22 feet or maybe a little bit more. What you heard Mr. Reppinger talk about is that there was a 42-foot distance, and that doesn't seem to work, at least geographically looking at this, because if we have about a 22 or 25-foot hood on that boat, that's going to give us some sort of frame of reference. And I think what you're going to hear from Mr. Guthrie is that when you measure the end of his boat slip to the lot line, which is where they're trying to hem this structure into, we're dealing with 25 feet. And Mr. Guthrie has a 22-foot boat. That doesn't include the outboard. The outboard's going to add about 2 feet. So we're talking about 24 feet, meaning 1 foot worth of play. Now, I don't know how much all of you do parallel parking, but 1 foot isn't a lot. It's difficult. And they're trying to have you, Mr. Guthrie, do this with essentially a 24-foot boat. So this is what they're saying the variance is going to be. We've kind of estimated around where Mr. Guthrie has his boat slip. I think it's telling that when the Beckstroms asked for this variance, they didn't measure how much distance you really have to the end of that boat slip. We didn't do any sort of survey. We don't have any of that information. All we have is just people going out there with measuring tapes, and from what Mr. Beckstrom, or what Mr. Guthrie has measured, we have 25 feet to work with this plan. Now, the new plan is actually worse than the old plan. The good thing about the new plan is, and it's kind of hard to see, but you do have some space to kind of come in here, back in the boat and come out this way. You don't really have that extra space because what we're dealing with is that piling is really right here. The other piling's right here, so there is extra room to move here if that boat isn't parked. So this shows the state of the property in 2018. This would have been before the Beckstroms purchased it, and this would be at least where things were. This was not a problem because, again, you could bring that boat out here, back it up, and come out.
Can you say that again?
Yeah, so if Mr. Guthrie's boat is parked right here, if you total it up, it's about 24 feet that he has of boat when you add the outboard motors in, and I think that might be the outboard right there. So we have, onto the old plan, he could back out this way, angle in a little bit this way, and then move out. When you take up all this space, he can't really back out. He has to essentially go out here, and then he's got 1 foot to go zigzagging out in order to get loose and come out this way.
Would you entertain a question?
Yes.
Yeah.
So in this old configuration, Mr. Guthrie is actually crossing the property line to back out of his slot?
That's what he was doing before, yes.
Yes, so he's crossing their property line to get his boat out.
Yeah, if you call it a property line, I mean,
Well, it's in the
Projection line.
projection line.
they don't own the thing in the canal. So it's not exactly their property, but you have rights to use the canal. So.
Yes, yes.
Um,
People do.
You know, what I think you saw in the video is Mr. Guthrie coming around in this way. You can understand how it's much easier to pull into this slip than it would be to pull out. So this is also the old configuration. If you kind of look at where the boundary lines are, that you have that one piling that was within the approximate lines once you take them out into the water. So everything was in. It was not compliant with the 7.5-foot setbacks, but it did provide Mr. Guthrie with sufficient room to back out and navigate outward. This is another picture. I think the lines are a little bit wrong. This probably comes out this way, but this is another picture. This would have been around the condition of the property around when the Beckstroms purchased the property in December 16th, 2021. So here's the permit history. We had some representations by the Beckstrom's attorney that this current structure was approved, and that's not what the permit history reflects. We have the relevant permits here on Bass. We have the 2018 one. I think that was the one that was expired from the previous owner that was discussed. Then we have this 2022 RES Marine Construction and 2022 RES Electrical. Those were the two ones that Mr. Beckstrom was presenting an argument that the new structure got approved through those permits. And if you look at the first one, which was the boat lift, they say, describe the work to be done, new boat lift and dock. It's not say new, it does not say that they are moving that. Well, this was the 2018 one. This was the one that closed out, the new boat lift and dock. So it's clearly identified what's being done here. This is the correct way to put up a boat lift and dock, is to clearly identify it. And they also say right here, this is where we're planning to put the pilings. Those pilings are essentially the what we saw in the pictures. They're essentially looking to put the pilings in the exact same place where they were before. And if that was the plan here today, Mr. Guthrie wouldn't have a problem with it. He didn't have a problem with where the old pilings were. So this is, again, another, going back to that picture of what things looked like around when the Beckstroms purchased the property. This would have been the first permit relating to the waterfront that from 2002. Again, that we have a description that it says seawall, not a boat lift. And when we have the actual physical application, they say new seawall construction. There's no mention that there's going to be a boat lift. This was part of the plans. Again, these are engineering plans. These are not necessarily plans up for the boat lift. If we look at these plans, we're going to zoom in here into the box in red. And if you look right here, it says new seawall construction. It doesn't say new boat lift construction. And we zoom in and it says proposed future boat lift by others. So they were making it clear to the building department, hey, this isn't part of the plans right now. This isn't what's getting approved. It's proposed for future for a future permit application. And then this was the as-built survey showing what actually was done once they built the seawall and put in the new boat lift without any permit or approval. And if you look at what happened is they built the new seawall, then they extended it out about 2.5 feet, and then they added, it's about 2.6 right here. So they actually moved the whole structure further out, giving less room to work with when they built the new boat lift. So, you know, the old piling was probably somewhere around here, and now we're moving that piling out here. If we look at here, they say that this is about 2.6 feet, so we're dealing with something more than that. This is the other permit. This is the marine construction. So we have, this is where one of the code violation comes about. They say that there's work without a permit. Essentially, that's the boat lift that was done without that permit. All the documents said, hey, we're just putting in a seawall. Maybe we're putting in a boat lift later. And then they put in the boat lift without getting permit approval for it. This is the electrical.
I just wanted to interject a
Yep.
question. On the previous one, gather my thoughts. So the boat lift that was put in without the permit ended up with a code violation.
Yeah, that's
And that's what the I don't know if this is the previous slide.
that's why we're here today.
Okay.
The Beckstrom's attorney said, quote, they did everything that they could do to get it permitted, and that's not the case. They did the work without getting a permit.
And we're caught, or,
So,
and coded.
yeah.
Okay.
So, I mean, if you were going to do everything to get it permitted, we'd have a file.
Okay. Did this code violation get cured?
It's not cured. They've kind of put it on hold to see what happens
Okay.
with this variance hearing.
Okay, thank you.
So, and that's my understanding. I could be wrong, maybe. Building department has more information, but that's my understanding.
My understanding that the variance today would remedy the piling that's outside of the property line as it projects into the canal.
Which is that code violation?
Correct.
Okay.
So, this is the electrical work. Again, what they're looking to do is they say, wire new boat lift install, you know, all this kind of stuff. Essentially, put things on the current pilings. Again, they never got a permit for those pilings. This is one of their submissions. If you look at the submissions, they're not really showing where the lot lines are, but they gave a description of the new boat lift that is much smaller than the actual boat lift where the pilings are. And then they give the engineering for a boat lift, which is standard engineering. There really isn't anything that needs to get rejected here since it is standard. And in 2023, this is what we're left with. We've got the pilings going out and additional structures jutting out into the water towards Mr. Guthrie's side of the water. And it's important to note that, you know, right here we do have the neighbors' boat lift. Mr. Guthrie isn't doing this out of spite. You know, he doesn't have a problem with the neighbor being over the lot lines. He has a problem with this right here because there is not a sufficient amount of space.
Mr. Chair, I'm sorry. I want to make sure that everyone understands what's before you. The applicant today, with the plan that he shows that piling being moved, which meets code. The variances before you are for the side setback. Our code requires a minimum of 7.5 feet from the side property lines. The applicant is asking for 100% variance to that. So that's the two variances that are before you. It's not about the piling that goes across that property line. That will be solved when and if this
Right.
variance gets, these variances.
That's permitting versus zoning.
Correct, but
Okay.
that's what's on the table today, is for the applicant to remove that piling and the two variances for the side setbacks.
Okay. Thank you for that clarification.
So, this is another picture of what the conditions of the property is here now. This neighbor to the north and east, he's got a boat lift that goes over the line. Mr. Guthrie does not have a problem with that. And as we're going to get deeper into the, what the zoning requires, is it allows these type of things to happen, going over the lines, when you've got the consent or the collaboration with the other
Yeah, the
lot
code has
owner.
changed since then. It does not allow people to do two permits together to have them not meet, to have them not have a setback. Code has been changed.
And when did that happen?
That happened about 3 years ago.
Well, I think what's on the current, says that if they, neighbors jointly do one dock across the boundary line, they can do that. Are you saying that the code doesn't say that anymore?
It was changed in 2021, April 20th.
Okay. So, I mean, I think that's going to explain why you have a lot of this going on, and a lot of the pictures transgressing the lines that Mr. Reppinger showed, as he had ways for the neighboring owner to give the consent to build on the other line. Certainly, we did have a letter of support from Maria Samuda and Thomas Fagans. They're the ones that live right here to the south. If that was still permitted to allow one owner to build on the other owner's property with their consent, you have multiple ways where you can build a boat dock that still abides by the setbacks with Mr. Guthrie's lot, but overhangs onto the lot to the south. And they're the ones that saying, they're the neighbors saying, let the Beckstroms have their boat lift. So if they do want to do that, they have, I think they might have an option to submit a plan to allow the Beckstroms to build it on their side of the lot lines. This is where things currently are. You're showing that overhang with the boat from the lot line. This was done without any discussion with Mr. Guthrie. And this is one of the current violation cases. There's one against the contractor, William Thiel, saying that he did work without a permit. And then there's another code enforcement case regarding putting a ramp without a permit and blocking the canal right away. So what we're ultimately here for is the new plan, and we're going to get into that. These are the standards set by code for getting a variance. One is that the variance is authorized due to circumstances unique to the applicant's property itself and not shared by other property in the area. There exists an undue and unnecessary hardship created by the zoning regulations. That's the broad language that defines generally when you can get a variance. We're going to go deeper into that language about talking about undue and unnecessary hardship, but the way that courts have interpreted that language, it's essentially that you have to meet the 6 elements that we're going to get into, and the hardship, the whole idea of hardship is that there is no reasonable use of the property without the variance. It's a high standard. Again, in the section 62-253 of the code, we again are using that language, unnecessary and undue hardship. We're going to get into the 6 elements for a variance. But I do want to go here briefly, which is the part of the code that requires the variance. So 62.2118, that's the part that talks about setbacks, and it says, in cases where a public works director determines that the proposed dock or pier may interfere with the primary function of the drainage easement or right-of-way, the applicant may be required to obtain approval from the Board of County Commissioners. Now, there hasn't been a determination, as far as I know, from the Public Works Director, but you do have in the code considerations that the navigability of the canal needs to be considered. So then we have in subsection D, boat dock, covered boat dock or pier, including piling, shall extend no closer than 7½ feet to the side of the property line as projected in a straight line into the waterway. Where 2 abutting properties sharing canal frontage submit concurrent permits or dock structures, there's no minimum side setback from the shared property.
That is not in the code today.
Okay. This is what I got from the website yesterday, so I guess they haven't updated it.
Muni code is as it updated.
Okay. So, so we talked about the neighbor to the south. If that was permitted, you could get consent from the neighbor to the south to build a structure that's still abided by Mr. Guthrie's setbacks. So dealing with issue number 1, that special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. Circumstances aren't unique. There are numerous corner lots with these same restrictions. This is what's built into the purchase price of corner lots. They are less desirable than lots with more riverfront access. If you were to talk to any sort of realtor or appraiser, they build in a price per foot of waterfront into the valuation of the property. This is why corner lots are not going to yield a higher value than something with more water frontage. So essentially, what that also means is the difficulties of the property are baked into the price when you buy a corner lot. There are plenty of uses for a corner lot that don't require a 22-foot boat. You've got jet skis, you've got canoes, you've got paddle boards and kayaks. There are smaller crafts that you can fit into these spaces. But essentially what was done by the Beckstrom here is they essentially came to the problem. They bought a property that was too small for their boat. They did construction without talking to the neighbors, without getting a permit, and then they try to get what they want anyway, even though that 22-foot boat, as is currently planned, is not going to work for the spacing. So here's some of the other corner lots. And you can see just visibly, this isn't a unique situation. People have corner lots, and if the spaces are too tight, the building a dock is not going to work. This is 101 via Havari, Merritt Island. That's in the packet. We have 225 Inlet Avenue, Merritt Island, Florida. And then 1660 Vega Avenue in Merritt Island. All these are corner lots who, at least with the neighboring structures, are restricted in their availability to build a boat dock for a large vessel such as the Beckstroms. So this is not a unique situation. Item number 2, the special conditions and circumstances do not result from the actions of the applicant. Here they do. The Beckstroms chose to purchase the property. We're going to get into 3 cases that talk about issues regarding variances, but the case of Elwin versus City of Miami cited here essentially said that when you choose to purchase a property with a hardship, that disqualifies you from a variance. You don't get to come to the hardship and then whine about it and ask for a variance because of what you chose. It's having your cake and eating it too. So the other actions are the Beckstroms moved the seawall about 2.4 feet at least, creating more confined conditions for the subject property. In addition, they chose to have a 22-foot boat. A smaller craft would fit in the given space without these navigation issues. There are other circumstances that result from the actions of the applicant. Again, they were the one that chose to build the previous structure without a permit. They're trying to use the variance as a way to get out of that. So they built without a permit, and they did not talk to Mr. Guthrie to get any sort of discussion as to what he needs for navigability. So here's the kind of cross-section of the current and proposed variance. As we discussed, this is what they're proposing. They're not asking that this body ratify the current structure. Number 3 is that the granting of the variance requested will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, building, or structures in the identical zoning classification. It would violate this provision. It would grant a special privilege. All corner lots have similar concerns. If there are exceptions for corner lots, this is going to essentially be like a change written into the code. Essentially, anyone can apply for a variance and crowd out other owners from the corner. It would be at the expense of Mr. Guthrie. The 7.5-foot setbacks permit adequate navigation to Mr. Guthrie. A plan without the setback interferes with that navigation, and it would negatively affect Mr. Guthrie's property values. If he is only given 1 foot of navigation space, that's going to affect any sort of resale value associated with his property. And as a bit of a preview, we have Josh Long here, who is in the business of building boat docks and lifts. His opinion is that the standard minimum space that you need is 5 feet, not 1 foot. And the recommended space is 10 foot. So they're exceeding the space needed by industry standards by only giving my client 1 foot worth of space for ingress and egress into his boat lift. So essentially, if the variance is granted, it's taking away those extra feet that my client has to navigate in and out. 4 is that literal interpretation of the provisions of this chapter would deprive applicants of rights commonly enjoyed by other properties of the identical zoning classification under the provisions of this chapter will constitute undue hardship on the applicant. And we're going to get into this more in detail when we go into the cases, but we have the unnecessary and undue hardship. Those are the big picture items here. The case law says that means there's no reasonable use of the property. That's what you have to meet for this element. So, I think what hasn't been shown here is that they can't use that property. They have a house on it, so they're able to use it for a house. They've got a waterfront, so they can always put whatever they want on the boat dock, and they can also use it for smaller craft. There's no universe for this lot where there is no use of the property without the variance. So that it's impossible for them to meet this this element of the variance. 5 is that the variance granted is the minimum variance that will make possible the reasonable use of the land, building, and structure. Well, again, lift for a smaller boat, for paddling vessels, jet ski, those are options. Those aren't here. Neighbor of the south, that looks under the old code, could have consented. Then we also have what's going to be a third option that's not listed here that I think Josh Long will discuss. They do make boat lifts where you lift the boat out and you bring at least some of that boat over the land, over the seawall and onto the land. So there is that third option that the Beckstroms have to still comply with setback requirements and give Mr. Guthrie his navigational rights. They can create that lift that brings the boat onto their property. So just if we go back, what that would look like is here's their current plan. You could build something that pulls the boat over the seawall, and some of the boat is going to be hanging over the land. Number 6, that the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such use variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Well, it's detrimental because it negatively affects Mr. Guthrie's rights of ingress and egress. And the variance would negatively affect his property value because now his rights of ingress and egress have been greatly diminished. So this is going to be the first case I talk about, the Elwin versus City of Miami case. It's in the packet. What you'll find is going through a lot of the cases is very rarely can someone meet the elements of a variance, at least under when it's reviewed by a court. So what the Elwin court said is some exceptional and undue hardship to the property or to the individual landowner unique to that parcel of property and not shared by property owners in the area is an essential prerequisite to granting of such a variance. So you need to show exceptional and undue hardship. They continue a variance which permits a use not authorized by an existing zoning classification fixed under a plan zoning of the area or neighborhood generally is not justified unless the land cannot yield a reasonable return when used for purposes authorized in its present zoning. There's been no evidence of this at all. This is what was required to show undue hardship under the standards, that they have essentially no use that they can make of the property without obtaining the variance. The case continues talking about the variance at issue. The complainant showed that the hardship was self-created and self-imposed. One who purchases property while it is in a certain known zoning classification ordinarily will not be heard to claim as a hardship a factor or factors which existed at the time he acquired the property. So buying a piece of property with problems, that's not hardship under the variance requirement. The case continues. When the owner himself, by his own conduct, creates the exact hardship which he alleges to exist, he certainly should not be permitted to take advantage of it. Essentially, buying the property, you don't get to buy the property with problems and then complain about it. The Herrera versus Miami case talks about that issue of harms. A variance which permits a use not authorized by existing zoning restrictions for a neighborhood is not justified unless no reasonable use can be made of the land without the variance. That has not been showed. Again, they go into what that means. Where land is zoned for residential use, deprivation of all beneficial use is proved only when it is established by competent evidence that the land cannot be used for any of the purposes permitted in such district. The case eventually reversed the variance because there was no finding, quote, without the variance, it is virtually impossible to use the land as is presently zoned. That is impossible to be shown here when the Beckstroms are using the property for a house with waterfront views. The case went on to reverse the variance because there was no finding, quote, the alleged hardship was not created by the applicant. That's also going to be impossible here, where the Beckstroms created the situation and purchased the property with at least knowing or should have known knowledge of the conditions. The court goes on to say that the neighboring property owners, like Mr. Guthrie here, had a right to rely on existing zoning conditions, and they had a right to a continuation of those conditions in the absence of showing that a variance was necessary. And the last quote from that case, the standard is not whether variances have been granted to similarly situated applicants in the community or whether the grant of the variance would have a deleterious impact on the surrounding area. So when Mr. Beckstrom's attorney goes and looks at all these other properties, some of which may have existed under a different zoning regime, those are not going to be things that the body can use to evaluate the variance. Essentially, you have to hem it into those 6 requirements that we discussed, none of which the Beckstroms have met. And then the last case is Nance versus Indian Atlantic. The court said that a prerequisite to the granting of a hardship zoning variance is the presence of an exceptional and unique hardship to the individual landowner, unique to that parcel and not shared by other property owners in the area. We've shown that this is a common problem for corner lots, especially in the Diana Shores area. This was dealing with India Atlantic, which is not too dissimilar from Merritt Island with the canal structure. But what was dealt with in India Atlantic is not a canal. It was requesting a variance, height variance for building on the beach. And the court said that, that was not something that could justify the variance. They said India Atlantic's zoning restrictions are common difficulties shared by all other oceanfront lot owners in the area, and therefore not the unique hardship required to support a variance. So essentially, if you take that to corner lots here, if corner lots are having to deal with the same problems, that's not going to be unique to you. That's not going to fit that prong of the 6 elements required. So, this kind of just goes back to the approximate location on the survey. We don't know how accurate this is, but this is at least what Mr. Guthrie has measured, 25 feet. It is not going to be sufficient for navigation. While there are plenty of neighbors who believe the Beckstroms should have their property, they're not the ones that have to deal with the navigational issues. Mr. Guthrie does. Under these circumstances, the variance should be denied, and we have Mr. Guthrie, Josh Long, and Patty Hill that have things to say in support of denying the variance. Oh, and the other important thing to mention, because this did come up in the last hearing, is that there is litigation regarding the current structure, not the variance structure. The litigation for the current structure essentially says that they did not comply with the 7.5-foot setbacks. This issue is subject to that court case. The trial was scheduled to be in January. That's been continued. I don't know when it's going to be, but this issue is subject to the litigation in that case with the court.
I take it walking away is your conclusion to the presentation.
Yeah, that's my conclusion. So I want Mr. Guthrie, well, we'll use Mr. Guthrie first, and then it will be.
Please come forward. Are you Mr. and Mrs. Guthrie, or is?
My fiance.
Well, you can come together, is what I'm,
No, she has her own things to discuss.
okay. Name and address for the record.
My name is Tom Guthrie. I reside at 315 Artemis Boulevard, Merritt Island.
Okay. Do you swear that the testimony you're giving us today is the truth?
I do.
Okay. I just want to remind you of something I said at the very beginning of our proceedings today, and that I'm asking you to stay on point and be concise and avoid any discussion of personal animus with the neighbors.
Okay.
Okay, thank you.
Well, at the beginning of the Beckstrom's presentation, they brought up some issues of hostility. There's never been any hostility on my part. The only conversation I had with Mr. Beckstrom was when he had his piling and the roof to his boat dock overhanging my property line. And his response was, "You take care of your property and I'll take care of mine." Mr. Beckstrom also took care of my property by moving my fence without my permission and installing his seawall on my property. I made no issues with that. The Beckstrom's own surveyor, Nielsen Surveying, put a surveyor's tag in the middle of on the seawall, and that tag number is LB 6946. I filed a complaint with code enforcement. Margaret Castellano, Contractors Code Compliance Officer, was my contact for my complaint. I periodically would call her for an update on my case and was told on more than one occasion she was investigating the contractor and the complaint. I don't know what the results of that investigation into the contractor was. After a period of time, my attorney told me the Beckstroms are currently in violation of the building codes as confirmed by Inspector Castellano. Beckstrom's attorney stated that he did an air measurement of the area I have to back my boat out of 40 feet. If I had 40 feet to back my boat out, I wouldn't be here today, and I wouldn't be going through the expense of defending my property. I did a physical measurement, because I didn't understand what an air measurement was. I did a physical measurement from the property line to the area that I have to back out with a tape measure and recorded 25 feet. I have a 22-foot boat with an outboard motor, and if the variance is granted, the Beckstrom's boat will be on the property line, and I will have restrictions on 3 sides. My dock to the front and my lift, a seawall to the left, and the Beckstrom's boat on the property line. The Beckstrom's boat would be directly behind me. And if the variance is granted, the only way to get my boat out is to physically push it sideways out of the area. I have 100% disability from the Mass Department of Corrections, and I've had multiple back surgeries, the last being in November. Not being able to back my boat out would be a hardship for me. I have been docking my boat for the past 10 years until the Beckstroms bought their property. And I want to make note that one of the pictures that the Beckstroms' attorney took, that house was abandoned for 5 years. And that dock he keeps mentioning was falling in the water. And I used to have to take my boat out by rope. I couldn't back it out. A friend of the Beckstroms stated that he could back his 26-foot boat out of the area I described. This person lives 7 houses down on the canal and has never stepped foot on my property, or has he ever witnessed me backing my boat out. The contractor for the Beckstroms also stated he could back his 30-foot barge out of that same area. To me, that defies common sense. The Beckstroms have shown a video from a distance showing me entering my boat lift. The Beckstroms would not show a video of me backing my boat out, so the board would get a complete picture of the entire picture. The reason they did not video me backing my boat out can only be answered by the Beckstroms' attorney and the Beckstroms. The Beckstroms' latest proposal shows his boat on the property line, which gives me no relief in backing my boat out. This would create a hazard of me hitting his boat and damaging mine. So instead of hitting a piling, I'm going to hit the side of his boat when I back out. The latest proposal makes no mention of the roof that he has over his boat lift. The roof measures 34 inches from the side pilings and 10 feet from the front pilings. This would not conform to the variance that they are asking. The 10 feet from the front piling would place the roof overhang approximately 4 to 6 feet over my property again. The Beckstroms' desire to have a large boat on a small waterfront with restrictions should not be allowed to impact the use of my property. Brevard County building codes are there for a reason, to protect landowners and homeowners. Granting this variance will permanently have a negative effect on my property and the market value of my home. Thank you.
Thank you. Do any of the board members have questions for this witness?
One question. When was the last time you were on your boat? I'm sorry.
I-
When was the
Probably-
last time you were on your boat?
Probably about 8 months ago.
8 months ago?
I haven't used it in ages. It's probably when they recorded me entering my boat lift.
Is there a reason for that? 8
Yeah,
months?
some physical problems.
Okay.
The only pleasure I had was going out in my boat by myself. Now I have to make sure I have an able-bodied person with me to push my boat out sideways.
Okay. Anyone else?
I have a question. I don't see it anywhere in here. What's the actual frontage of your property?
The water frontage,
Correct.
80 feet.
80 feet?
Mhm.
Okay.
Thank you.
All set?
Can I inquire of the speaker?
No, it's,
There's no cross-examination from what I understand. No, you don't.
I have a right to cross-examine.
We're not in court.
Greg?
Greg,
He's asking to cross-examine?
Since he has counsel, he can cross-examine.
All right. Briefly, please.
I just want to, can we pull up the video image that's on the screen right now? Is that your catamaran?
No.
It's reflected in that picture?
No.
Whose catamaran is that?
Josh and Marissa Long.
And how long was that, when was that catamaran moored at that location?
I don't know the exact dates.
Approximately how long?
What's the relevance of this?
I'm asking him a question. Approximately how long?
And I don't know the answer.
Was there a code enforcement violation filed against you for the housing of that catamaran there?
Yes, and that's what I couldn't understand. I had 30 days to correct that, and they've given an unlimited amount of time to correct their problem.
So you had you actually had a code enforcement citation for that?
Yes.
correct?
As to whether they should be granted.
I would have to defer to our counsel to,
You can allow it or not. As the finder of fact, you can allow it or not.
It was corrected.
I'm not a legal expert, I'm just a citizen volunteer here, so
Understood.
that's why I'm trying to.
Sure.
Give me some advice on how I should handle this.
Well, specifically, what is your question now?
Well, that they're cross-examining and objecting, and I'm just not used to that.
Well, and that's why I say you're going to basically act in the capacity of the finder of
Greg, can you
fact.
turn your microphone
Yes,
on?
so-
I can't hear
Oh,
you.
sorry.
Yeah.
You're going to act in the capacity of the finder of fact, so you can allow it or not.
So I can say objection
If-
overruled like they do in
Or
TV.
sustained, yeah.
All
Yes.
right.
Can I explain the circumstances for that boat being there?
Sure, since it was brought up.
The Port Canaveral Yacht Club was installing all new docks, and his slip was gone, and I gave him the opportunity of parking his boat at my dock until the new slips were brought in.
What was the
The new
duration
docks.
of that?
Pardon me?
What was the duration of that docking?
I would say
Approximately.
probably
Weeks,
2 months. 2 months, maybe.
Couple months.
Mhm.
All right.
But the point is, that wasn't your boat.
Correct.
The point is, you didn't drive that boat, that wasn't his boat, and it was just housed there for that
Well,
time.
at his permission, so therefore
Correct.
he did have control of it.
Okay.
Yeah. Well, I guess on testimony. Anything else from the board here? All right, thank you.
Okay, thank you.
You also wanted to speak? I'm not encouraging, I'm just allowing you.
Good afternoon.
Name and address for the record, please.
My name is Joshua Long. I'm Vice President of Commercial Development for AccuDoc, and business address 1790 Southwest 13th Court, Pompano Beach, Florida.
Okay. I'll swear you in first. Do you swear that the testimony you're giving us today is the truth?
Yes, sir.
Okay. Credentials, are you licensed as a contractor or anything like that?
No, sir. I'm not a licensed contractor. I work for AccuDoc as a vice president for their commercial development side. I work on engineering and design processes for basically large-scale marinas. But I'm friends with Tom, and he had asked me to talk about standard processes of design work and stuff.
Okay. Go ahead.
So, as I said before, I know Tom. The Beckstroms, I don't know. I'm sure they're fine people. I don't know much of the argument. About a week ago, Tom, who's a member of my yacht club, approached me and said, hey, having some troubles trying to wrap my head around how all this works. Could you come talk to me? I went to his home and spoke to him about, what we do as a design process for designing docks and moving boats and how that kind of works. And I'm just going to speak on that and facts and not so much the case, but just more about how docks and what we do in certain situations. So as Tom's attorney spoke earlier, when we have a dock that we're designing and there's a set slip length, let's, for argument's sake, that set slip length is 40 feet, meaning that slip can hold a 40-foot vessel. That means the fairway that vessel comes down and has room to maneuver 90 degrees is going to be set somewhere between the ranges of 50 to 60 feet on average. So we tried to do not less than 5 feet front and rear or, of the vessel, and not more than 10 feet for sake of saving room, So Tom, terribly sorry. Tom had went out there with the measuring tape as he spoke earlier and said, look, I only have 25 feet here. I have a 24-foot vessel. What would you do in this situation? And I had to clarify. I said, well, what do you mean, what would I do? And he's like, if you were the neighbors, what would you do? And I said, well, if I was required to do something, davits would be the situation that I would do. And that was just all that was asked. Davits, if you don't know, are seawall cranes that are able to lift a vessel up and towards the seawall more. Doesn't leave any pilings or anything out in the water and leaves clearances underneath of it for movement. So that's what was asked of me. And just to clarify, because I know it was asked, that vessel that's in that image is my vessel. As I said, Tom is a member of the same yacht club that I'm a member of. And during the reconstruction of our yacht club, he allowed me to park it there. It was there for, as he stated, a couple months till he got notice that that he was in violation, and he asked me to move it, which I did immediately upon request. So, and I owe him a great deal of thanks for that opportunity. So, but besides that, as I said, that's basically all I have to say. Mine was more on a technical value on design process, and in that type of situation, look, it would behoove me to sell a dock if I could to the Beckstroms, but that's not the case. I think
So that's your boat?
that is my vessel.
Okay.
Yes, ma'am. So, but
That was my next thing.
yeah.
That was my next procedure, was to see if any of the board had questions, but they jumped the gun on me.
Yeah, that's basically all I have to say.
Okay.
It's more of a
Any-
technical value.
So hold on. Any questions from board?
Actually, I take that back. What is the length of your boat?
My vessel is 36 feet, which is about close to the full length of his dock. If it wasn't, I think it was the full length of his dock. I can't remember exactly, but we squeezed it in there. It was tight. So, yeah.
Okay. Thank you.
Thank you.
As I stated early on, we've had some flexibility here, but as I said, anyone from the audience wishing to speak will be given the opportunity to address the board only once. However, I will violate that, and if you have any concluding words, and then that will be the end of the opposition.
I've said my part, but Patty.
Oh, I'm sorry. I thought we only had two, and I apologize for that.
Hello.
So, name and address for the record.
Oh, Patricia Hill, 315 Artemis Boulevard, Merritt Island, Florida.
Okay, and do you swear that the testimony you're giving us today is the truth?
Yes.
Okay.
Okay.
Speaking in opposition, or for or against the approval of the application?
Opposing the approval
Opposing it.
of the
Okay,
variance.
thank you. I forgot to ask the others for
Okay.
the record.
I'll try to make this short. I'm here today to explain a few facts that I think are important about the case. Our neighbor, Mr. and Mrs. Beckstrom, they filed a variance to eliminate the 7.5-foot setback on our property. If the Beckstroms were granted this variance, it would impede on our riparian rights as well as provide a hardship for us. The Beckstroms have a pattern of infringing on Mr. Guthrie's property rights. They have demonstrated that they don't respect Mr. Guthrie's property rights, and they don't follow the guidelines for zoning and ordinances. Let me explain. First, they moved the Tom's fence back and took some of Tom's property. They did this knowingly, as the surveyor has the mark, a permanent mark on their seawall displaying the property line. The Beckstroms moved Tom's fence without asking him and infringed on his property. Tom has never and would never encroach on the Beckstroms' property. Did Tom ask them to move it back? No, he didn't. Next, when the Beckstroms built their new seawall, they again built it on Tom Guthrie's property. They did this without asking Tom. Tom Guthrie has never, and he would never, encroach on their property. Did Tom ask the Beckstroms to go to the expense of moving the seawall back on their own property? No, he did not. When the Beckstroms built their new dock, they built a much bigger one, larger one. Tom tried to talk to Mr. Beckstrom about the new dock and the property lines. Mr. Beckstrom said, "You take care of your property, I'll take care of mine." The new dock, larger dock, was built on Tom's property, as well as violating ordinance section 62-2118. Section 62-2118 is about residential boat docks and piers. It says boat docks, covered boat docks, or piers, including pylons, together with moored vessels or watercraft of any waterway encroachment shall maintain a clear navigable zone by extending no closer than 7.5 feet to the side property line, as projected in a straight line into the waterway. The Beckstrom's boat lift does not comply with the 7.5-foot setback. This new boat lift, which is much larger than the old one, causes a hardship for Tom Guthrie to safely navigate his boat out of the dock. The new boat lift makes it very difficult and dangerous to back the boat out into the canal. With the Beckstrom's oat boat lift, Tom could sit in the driver's seat of the boat and back into the canal easily. Now the process is much more difficult. With the larger boat they have built, Tom has to back up the boat a short distance, jump out of the driver's seat, run to the other side of the boat, take a metal pole and push on the pylon, trying to turn the back of the boat to prevent the hitting the Beckstrom's dock. Many times it takes 2 to 3 times before he can line it up successfully. I have personally been in the boat and I've seen the danger and the difficulty it presents. On windy days, it's almost impossible. He just used to sit in the driver's seat and back up the boat. Now, Tom is disabled and recently had back surgery, so we rarely use the boat anymore due to the hardship. The ordinance was created to maintain a clear, navigable zone for people to navigate their boats. The Beckstroms have already taken part of Tom's property rights with no regard or consideration. Tom tried to talk to them about this new dock to prevent this problem. The Beckstroms keep taking Tom's property and ignoring his rights. Tom has never, and he never would, infringe on their property rights, even though they have continued to take his. He now has to absorb the financial burden of counsel to defend his rights and protect his property at no fault of his own. In addition to the financial hardship, granting the variance could deflate his property value. Another point I want to bring up is that the letters stating that from the neighbors supporting the variance, it basically said that we like the Beckstroms and we want you to grant this variance, but there weren't any facts given to substantiate the variance. And none of the people that would be affected by this variance, or none of these people that wrote these letters are affected by this variance. None of them live right next door. None of them have this difficulty backing their boat out. I just think that that's important to put out there. But on the other hand, I have been in the boat and personally witnessed the difficulty and the safety issues it presents. The first time that he asked me to push on the pylon with the pole, we were actually coming in, which is much easier than going out. I actually thought I would just go up there and push on the pole, but the weight of the boat and just the water moving and stuff, it actually like pushed me back, jerked me back, and it scared me. And I told him, you can break your arm doing this. So I just want you to know that all these people that say it's easy and stuff, they haven't done it. They haven't been in that boat. You know, they're just saying it for whatever reason, but it's not really the facts. The facts are it is a hardship to back that boat out. And that's why we don't really use it as much anymore with his health issues and stuff. He can't jump up there and push on the pylon to turn that boat the way it needs to be turned. And I'm nervous, by the way. Okay, so just a little more. 1, 2, 3. Okay. Second, third. Okay. The section 62-253. This is the last thing I want to mention. The prerequisites for granting the variance states, in order to authorize any variance from the terms of this chapter, the Board of Adjustment shall find all of the following factors to exist. And then it lists the 6 factors. The lawyer went through all 6, showing that none of the factors exist. Therefore, the variance shouldn't be granted. But the easiest one that I find to see is the second one. It says that the special conditions and circumstances do not result from the actions of the applicant. The circumstances in this case do result from the applicant and his actions. He chose to buy a limited canal frontage with 23 feet versus Tom's 80-foot frontage. He chose to build a bigger boat lift than his property would allow. He chose to put his boat lift on Tom's property. So those actions and circumstances are a result of the applicant's action. So they have not met all 6. That's just one that they didn't meet. But so if you have to meet all of them. So because they didn't meet that one, he shouldn't be granted the variance. Please take all this into consideration. Thank you for taking the time to listen to these facts. I hope you will honor this ordinance and deny the variance that the Beckstroms are requesting. Thank you.
Hold, we may have some questions.
Okay.
Would you hold? Yeah. Any questions from the board?
I have a handful of questions that might include bringing Mr. Guthrie back up, too. I live in Merritt Island. I moved to Merritt Island in 1995, so I'm extremely familiar with all the waterfront. I'm currently a homeowner that lives on the water. I have had my real estate license since 2004. I am the owner-broker of Coastal Life Properties for the last 7 years, so I'm extremely familiar with these kinds of questions, these kinds of concerns. I wouldn't say that I agree with, everything that I've heard, but I think some of the key points that give me concern is the attorney mentioned that the neighbor was to grant a portion of the physical piece of the property. That would be the idea or resolution potentially that you recommended, when in fact the current owners, the Beckstroms, are allowing some of that property line for Mr. Guthrie to back into in order to access out. So my question is, I want to know how Mr. Guthrie navigates in and out of the canal. Does he back towards the 28 feet that the Beckstroms own and then he goes back forward, or does he back into the center of the canal?
He basically backs out enough to where he can throw the back end of the boat
East or
into
west?
the canal. Not towards their property, but away from it. Because if he went straight back, he would just hit it.
Right, which is the imaginary line in which I'm sorry, I forgot your name, but the opposing attorney suggested that he had to back into that variance or into that, the property space of the Beckstroms in order to I'm assuming, move back, out through the canal going forward versus backwards.
Well, the thing is, I
Correct?
think.
Am I correct in saying that? Is that the ideal way of entering?
Well, he can't
and
go all the way back into their property. He backs out a little bit and then swings the back end of the boat out towards the canal. And I think that's in our 7. I don't think we cross when we take the boat. I don't think we cross the property line. I think that's in our 7.5-foot setback area that we're when he pulls out that he's in.
Okay, I didn't seem to.
And that's
get
what
that
they're
from
wanting
it.
to take away, is that 7.5. The variance is wanting to take away the 7.5-foot setback.
The line in which the riparian rights enter into
Yes.
the canal. I'm aware of that part. My other question is I'm trying to do the math of the 25 feet versus 40 feet. I think that's my biggest discrepancy. Mr. Guthrie calculates 25 feet. The Beckstroms calculate 40. I did have the opportunity to go to the property to see it myself, so I was able to walk it and see, this, the visual of that. Like I said, I'm a bone owner myself. My family.
The 40 feet was an aerial provided by the Beckstroms, but
I didn't hear that.
Oh,
I didn't. I'm just going based on
Right.
the physical papers that I have in front of me.
There's not a 40-foot space between the boat, the end of the boat dock, and where they're.
The 40 feet was from the pylon to the pylon of the Mr. Guthrie's
Yeah.
boat
there's-
cover is what the Beckstroms are saying in this
Yeah.
paperwork. So again, I'm trying to
Yeah.
do the math.
It's
when it
my
comes
understanding,
to.
but I know that Josh measured it with Tom, and they came up, physically measured it just recently in the last week, and physically came up with the 25 feet. We have no idea about the 40 feet. There's no way.
Well, let's just assume it's there. You're both 50% not correct,
Mm-hmm.
right? So that would give you 32 feet to access, and then that would say that their 40 feet is 32 feet. Because I'm looking at it, and if you have an 80-foot piece of frontage on the canal, and I'm looking at a 36-foot boat, you're approximately 10 feet off of the east properties line. That's 45 feet. So I'm looking at 30 to 35 feet erring in the side of the opposition for access to get out of the back of the boat lift. And,
Well, I think-
and again, if someone wants to correct me on the
Yeah.
math, I am completely open to that. But I'm looking at the picture, and I know the distance between the fence line to the home and the area that you're allowed for every property in Brevard County. And I'm, again, saying that somewhere between the fence line to the The current existing boat dock for Mr. Guthrie's property is approximately 10, 15 if I'm being generous. You have a 36-foot vessel that's parked out front at an angle. So again, that's going to appear larger. That's approximately 50 feet. We have another 30 feet from that point, assuming.
I think that on his property, you're saying that the frontage there, it's the boat, our boat lift before his was put up was more towards the right side of that frontage versus the left side.
You mean the east side of the property?
Yeah.
I know, that's what I'm looking at. I'm looking at the current picture here.
But
that shows that. And again, I didn't need to like pick you for the person for the
Yeah.
questions, but all of them are kind of piling up, and I'm trying to come to that to me is the big deciding factor, because I think ultimately what we're trying to decide is, can you have physical use of your property the way that you would like to have it? Can they have physical use of their property the way that they would like to have it? And what's the resolution in between?
Right.
So
Well, I can say that we don't have our property the way it used to be. Like you
you
cannot.
can say that again? You do
I
or
would like
don't?
to say that we do not have use of our property as we used to before this new boat lift was built, that it is much harder, and I agree with them that there's only, with the measurement they did, there's only a small, the boat vessel, and what the space that's allowed is not sufficient, and it's not compared with to what we used to have.
I understand that, but then if I'm going to go back to the permits, because that's the other like tangible, physical, let me measure the numbers, right? The seawall was here, and we're just going to say here, and they added 18 inches because code said 18 inches is what you can go out, and that seawall permit passed, correct? So we may be 18 inches out farther than what we were already expecting. And then now we have this dock lift. So in my opinion, we're really only dealing with 18 inches to potentially 2 feet different than what you were already experiencing prior to any kind of lift, dock, pylon, any of that. Am I correct?
Well, the difference is when you try to take the boat out, there's a huge difference. Like he would
It
literally.
would have to be 18 inches.
It has to be more than that. Because he could just sit in his boat and back the boat out before. And now there's no way you can do it. There's just not enough room.
Is it because you think it's visual, because the lift is now up and
No, 'cause-
line of sight?
Nope, because we literally, you have to use a pole to push the boat, to swing the back of the boat to the side into the canal so you won't hit that new larger boat lift.
Okay. I think what I'm still missing is the difference between the 25 feet and the 40 feet. And if I'm going to be 50-50 on both sides and say that you're
I wonder where
incorrect.
you got the 40. Was that when they?
It's in the papers. It's in the papers that they measured. They said it's
Who
40
measured
feet.
it? Because Tom and.
I understand that. And I'm a neutral party, right? You're saying 25 feet, they're saying 40. That's a huge discrepancy for navigating in and out of the canal.
Yes, I
So
agree.
if I'm giving you 50% inaccuracy and giving them 50% inaccuracy, then ultimately we're following somewhere in between, 30 to 32 feet, which essentially would give a close to 10 feet clearance for him to be able to back out, because before it was 1 foot.
Yeah, but that's really, there is no way there's 40 feet there.
Okay,
That,
well, let's
like-
just say there's 32.
Well, there's really 25. So,
But I'm also looking, and I don't think you're hearing me, I'm looking at an 80-foot plot with a 36-foot boat. I'm giving 10 feet on the east side. That doesn't give me 80 feet. That doesn't give me 25 feet to fill the gap for navigation. Does that make sense?
May I interject?
Yeah.
It's not a matter of convincing this witness whether.
No,
what
I
you're
know, and
saying-
I think that's where I want the
And
I want
so
the return in
We'll have
convincing.
board discussion, I
Okay.
think, to talk that through.
Okay. All right,
Yeah.
that's where the only place I have discrepancy of
We'll-
like
we'll
trying to
talk
figure out the
about that as a
navigation.
board.
I have a question. If the variance, they're proposing a variance to take the 7.5-foot setback, and it causes such a hardship for us to back the boat out when it never used to, Why would it matter, like, what the difference, the space?
We appreciate your question, but I think we're not going to get a
Okay.
resolution, a consensus here, so.
Okay,
We understand your concern.
okay.
All right, is there anything else?
Nope.
Actually, we're at the point of any more board questions? Okay.
I mean, if anybody has any
Okay.
comments on what I said, that's just,
We'll-
that's where I'm.
We will
Okay.
comment.
Okay.
Thank you very much.
Okay, thank you.
Again, I usually say only once, but is there anything you want to say in conclusion? And briefly, please.
I just briefly on the 25 feet, 30, I think the boat was 36. I'm looking at it, just folded my paper, 36. Yeah, bring that over. I mean, it's less than 36 feet that we have to work with, just if we're using the white boat as a measurement, which we
Okay.
heard is 36. Now, what it actually is, I don't know. I wasn't the one that measured it. All we have is what Mr. Guthrie is, but it's definitely less than that 36-foot length of the boat, if that's what the length of the boat is.
Okay.
I know that you said you might have questions for Mr. Guthrie. I don't know if you guys still
I
do.
just wanted to make sure he can answer whatever concerns I put out there.
Did you want
And
to
how he
answer any of
navigates
those,
in
Mr.
and out of the
Guthrie?
canal, and it helps me understand the ability to use the property.
Of course, you're still under oath, sir.
Correct. The only thing I want to clarify was, I never heard of an air measurement taken and used as where that 40 feet came from an air measurement. That's why I physically went out with the tape measure and measured from the property line to the area I have to back my boat out.
The property line.
Correct. Where his boat will be right on the property line when I back out.
Okay.
Thank you.
Mr. Guthrie, just so, can you tell them how you?
You gotta be up to the mic, please.
Yeah,
Yep.
just
Can you tell them
speak into
how
the
you
mic.
backed out the boat? Because I think there's questions about that. When you were backing out the boat, how'd you do that?
Mr. Chair, can I interject for a second?
Yes, you may.
So your part of your discussion, if there's a question that you have for Mr. Guthrie, then you can ask it. It's not a give and take now. Does that make sense?
Yes, thank you for that, yes, direction.
Sorry.
It's a question and answer, and that's it.
That's it?
No.
So I can ask that.
Question?
How do you back out into the canal?
Okay, right
And
now,
answer.
I back into actually a three-sided box. My boat lift, seawall, and with if this is past, the Beckstrom's boat right on the property line directly behind me. So what I do is I back my boat out, and I have to leave the driver's seat. I have a deck pole. I have to get out, and I have to physically push my boat out sideways, which kind of defies the law of
So
boating.
you don't come into the canal and turn out? You back,
Going into my,
are you backing in west, or are you backing in
I'm
south?
backing, I have to back straight out to clear the front of my
So
dock.
south. Okay. And then you turn in the canal?
Well, to get out to the canal, I have to push my boat out sideways, which kind of defies.
Say that one more time?
To get my boat out of this three-sided box, I have to push my boat out sideways. I can't go forward, I can't go in reverse. I have to actually push my boat out sideways with the deck pole.
Are you in gear at any time?
No.
May
No, I'm in gear to back my boat out. Then I'm in neutral, and I have to get up out of the seat and actually push my boat out with the deck pole.
Could I see if I can clarify what he's saying? He backs out, takes and pushes the bow to make the turn so he's straightened into the canal, then he pulls ahead. Is that correct?
Yes.
Okay,
You pull into the little cove.
yes.
Area.
And twist the bow into the canal, pivoting on the motor.
Does anybody know the distance of the canal?
Well,
It's
gotta
fairly,
be-
it's fairly wide on our end.
yeah. Okay, Thank you.
Thank you.
All right. I'm sorry?
They have a rebuttal.
This is going to go back and forth for forever.
I'm not going to have anything else.
All right. Briefly, please.
I'm going to be brief. I'm going to do a summation, a very brief summation, but I am going to, because the question was asked, I am going to bring up Mr. Beckstrom to talk about the measurement of the pilings and the distance between the pilings. I think, Ms. Clements, I think you're right, and I would urge you to really think about your position on this, that what we're talking about is 2.5 feet, at max. At max, that's what we're talking about. Because the seawall was only pushed out about 18 inches. That's what it was. And that pushed the piling out and over the line. Before that, it was only 18 inches the other way. It's now 2.5 feet over the line. So before, it was either over the line or it was at the property line before. That's what it was before. And that's the way it was as Mr. Guthrie operated his boat for 9 years, preceding the movement 2.5 feet. We're not talking about 7.5 feet. We're not talking about that. The variance application is requesting a 7.5 foot variance because that's what the setback is.
Right.
But that's not what we're talking about in terms of movement and what Mr. Guthrie has been dealing with. It's literally 2.5 feet. And he didn't have a problem before. Now he does. Dr. Bass, I think you identified it perfectly, which is if he's got a problem, that means he's backing over the property line onto the Beckstrom's property. Perhaps Mr. Guthrie should reconfigure his dock if he's got a problem getting out. And maybe it's Mr. Guthrie's problem, but that's a whole nother story. Anyway, that answers the question as far as how far the post is moved. But I'll let Mr. Beckstrom explain how that measurement was taken, roughly 40 feet.
Have you been up to the microphone before?
I have not.
Okay, then name and address for the record, please.
John Beckstrom, 305 Artemis Boulevard, Merritt Island, Florida, 32953.
Okay. And do you swear that the testimony you're giving us today is the truth?
I do.
Okay. Please be concise.
I will, right? And I'm only going to talk about the measurement, right? So the measurement that I took was with a laser measuring device that I took from the piling in question to the rear canal side piling of Mr. Guthrie's boat lift. That measured 42 feet. I then, to verify that measurement, I measured from my back piling to my other neighbor's, Samuda's piling, and that measured 51 feet. To verify the laser, I then took a tape measure from my piling over to their piling and verified it was exactly 51 feet. So the measurement from my piling in question to the piling on the back of Mr. Guthrie's boat, the nearest one that he would have to clear, is 42 feet. The reason the 25 feet is there is last Thursday, Mr. Long came to Mr. Guthrie's property. I was on my boat. They dropped a tape measure through the fence onto my deck where the medallion is, and they measured from my seawall over to the back. So from a geometry perspective, if you look down the red line towards that 25-foot line, that 25 feet is not from the piling. That 25 feet is from the seawall to the back of his lift. As you follow that line down to my piling, you're moving further away from Mr. Guthrie's boat lift. So it's not 25 feet from the piling that he has to clear on my boat lift to the piling he has to clear on his boat lift. It is 42 feet. That's it. Thank you.
Okay. Thank you.
Very briefly, just a couple of clarifications that I feel obligated to make. First of all, the cases cited by Mr. Vidoni, that they're distinguishable. I've articulated and explained to this board that the BOA has granted numerous variances of similar kinds in this subdivision for zero lot line setbacks. We believe it's appropriate in those cases. We believe it's appropriate here. As far as the electrical permit, and I do feel the need to address this point just because it was raised, because I need the board to understand, or I would like the board at least to understand, that the Beckstroms did not do anything wrong in this case. With regard to the electrical permit, it was stated that the electrical didn't include the boat lift. Well, I'm looking directly at the county's Bass Permit Development website, and I can tell you that on that website, and I'm reading directly from the permit application for permit number 22 BC 20542, which is the electrical permit, to whom it may concern, I need to amend this permit application in the description on the permit application. Needs to say installing boat lift on existing poles, as well as what is listed in the description on the original application. Thank you, Curtis Standoff, Coastal Lighting Solutions, LLC. That was the electrical permit contractor. I'm not reading from anything that I created. This is on the county's permitting website. We are not misrepresenting to this board that we tried to pull permitting. We tried to pull permitting. The lift was at issue. I'm also going to show you from the county's permit website, from Bass, an exhibit, which is in permit number 22 BC 13847. That is the seawall permit. What that says, and what that is, it says reflective tape will be installed on both outermost pilings at 8 inches in width, top to bottom. Tape will be installed in the middle of the pilings, so they will be visible to all boat traffic. Does that sound like the pilings were involved in the permit? I mean, that is in the permit application. So to represent to this board that the Beckstroms did not ask for permitting for the boat lift is just, it's inaccurate. And it's not looking at the permit applications that were submitted. So in any event, the Beckstroms have done everything they can do to get this lift permitted properly. They are the defendants in the lawsuit, by the way. They're not the plaintiffs. Mr. Guthrie sued the Beckstroms. And that case is pending. And we hope that the grant of this variance will resolve that litigation, hopefully. And so we are asking for your support to grant the variance as has been requested. Thank you.
With that, all public discussion is closed. The action now moves to this side of the bar. And
Mr. Chair, I just want to make one other point of clarification. That the existing litigation, Brevard County is not a party to that litigation, so it really has no bearing on your ability to deal with the matter before you today. So.
Well, I'll clarify what you said. We take independent action here on what we find.
Yes.
And without regard to the legal.
Yes.
The litigation.
Yes.
Okay, great. So action moves to this side of the bar. Ms. Clemens, it arises in your district. Would you like to make a motion?
Yes, but I need help with how to say it.
Sonia's a great help for you.
Approve. Okay. Let's see, I don't even know if that's the right one. I make a motion to approve the survey as depicted and provided by the applicant with a revision date of 9/30/2024.
Can I just make a suggestion?
You may.
What I would suggest the motion be is approval of the two variances as depicted on the survey.
She will restate.
I make a motion to approve the survey of the two variances.
Approval of the two variances as depicted on the survey.
Okay. I make a motion to,
Approve.
to approve the two variances as depicted on the survey provided by the applicant with the revision date of 9/30/2024.
Do we have a second?
I'll second that.
Okay. We have a motion by Ms. Clemens to approve the application for the variance. We have a second from Dr. Bass. At this time, we will discuss the issues between us and among the board. I'll let anyone speak up? Dr. Bass, no? Sonia? I'm sorry. Ms. Millard.
That's okay.
I'll ask a question of you. Did you get a resolution on your dimensions and how that all comes about in your mind? It's a short answer, really.
Yes, I mean, I truly believe we're dealing with the distance of the old seawall to the new seawall.
Okay. Okay. Anything else? You've all made up your minds without listening to? These are never easy. These are never easy.
6 points.
So we're out to the 6 points then. All right. I will ask our honorable counsel has asked me in the past, and I would reiterate it now, that any negative vote, I would ask you to point to which of these 6 influenced your decision. I think that's, he's not his head.
Yes, since the 6 points relate to findings of facts, if you're voting against, we'd like to know, we'd like to know your basis for voting against,
Okay.
any one or more of the 6 findings of fact.
Okay. And in light of that, I will poll us each individually for that vote. Okay. The 6 criteria: that special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification; that the special conditions and circumstances do not result from the actions of the applicant; that gaining the variance requested will not confer on the applicant any special privilege that is denied by the provisions of the chapter to other lands, buildings, or structures in the identical zoning classification; that literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant; that the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure, and that granting the variance will be in harmony with the general intent and purposes of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Okay. I will go from right to left. Well, I'll go by district. District 1, Ms. Millard, how do you vote? Yay or nay?
Yay.
Yay, okay. District 2, Ms. Clemens.
Yay.
So votes yes. Dr. Bass?
Yes.
Okay. And Chair, I am going to enter a negative vote based on the minimal or the minimum that can be done, and also injurious to the area involved or otherwise detrimental to the public welfare. And with that, the application has passed and the variance is granted. We have a couple of announcements. I have one ahead of time and then one afterwards. Next month, one of our housekeeping duties is to elect new chairman and vice chairman for the board. And I had a predecessor here. I don't even quite remember his name, but he was chairman for about 5 or 6 years, and he began to think of it as a legacy and a right. And when I was elected about 3 or 4 years ago as the chairman, it did not go well with him, and he resigned. I have been chairman now for 3 or 4 years, and I think it's time to pass the torch. So I would like you to all think in your hearts about where you would like to step up.
I think it's time to pass
The torch, yes.
Yes,
I would stay
definitely.
on the board, but I would like to stay on the board as just a member, not an officer. So that's my announcement, and
May I
Mr.
recommend somebody?
Mr. Mr. Ball.
Thank you, Mr. Chair. I just want to let you know, I've made a difficult decision to leave county service. It's been a pleasure working with you all, and Ms. Clemens, sorry we didn't get the chance to work further, but I just wanted this, I will not be here at the next Board of Adjustment meeting, so I want to say thank you in allowing me and my staff to support you in the great work that you all do. So thank you.
So on behalf of the board, we appreciate everything you've done to support us here for the last, and personally, when I took over 4 years ago or 3 years ago, I don't even remember. Jeff spent about 2 hours on the phone with me going, okay, this is what you should be doing, and this is how that's interpreted, and it was a great help. It was a great help. So, thank you. All right. Go ahead, if you'd like to say something before I adjourn.
Yes.
Go ahead.
I wanted to make a recommendation for the new chair.
No, that's next month.
All right.
That's next month. Okay, well, I declare this Board of Adjustment meeting for December 18th, 2024 adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.